with our working session. Welcome everybody to this session, which is covering rule of law, including prevention of torture, an exchange of views on the question of abolition of capital punishment and the protection of human rights and fighting terrorism. Some of the questions that could be addressed during this session include, as they concern the prevention of torture, what are the main reasons for the persistence of torture in the OSCE region, despite clear and unequivocal commitments against torture, and how can these be addressed? What are some good practices from OSCE participating states in establishing strong and effective internal and external monitoring mechanisms, and what steps can be taken to allow MPMs to effectively carry out their work? What challenges need to be overcome to ensure accountability for torture and ill treatment and to provide victims with effective remedies? As concerns the issue of the death penalty and the exchange of views on the question of the abolition of capital punishment, some of the questions that we hope we will be addressing during this working session are what measures can be taken to make information available to the public regarding the use of the death penalty and to keep the question of the abolition under consideration. What measures states that retain the death penalty take towards its abolition and the implementation of alternatives, humane alternatives to it. And what steps are needed in law and practice to ensure that international legal obligations and commitments on the use of death penalty are observed, and in particular to ensure compliance with fair trial standards in capital cases. On the issue of the capital punishment, I would also like to announce that today we are publishing our annual background paper on the death penalty in the OSCE region, which in fact serves the purpose of providing an overview of relevant developments on the application of the death penalty throughout the region, the OSCE region, and we hope it contributes indeed to making information available to the public on the topic. The third area that we will be exploring during this working session is the protection of human rights and fighting terrorism. Again, some of the questions that we hope to address are what steps are being taken to ensure that counter-terrorism legislation and practices are targeted, proportionate, and human rights compliant. What efforts are underway in the OSCE region to address the phenomenon of foreign terrorist fighters and kidnapping for ransom in line with international human rights obligations and OSCE commitments in particular. How do OSCE participating states protect the right to life, the absolute prohibition of torture and other forms of ill treatment, and the principle, abide by the principle of non-refoulement? And what good practices are available with regard to efforts to prevent terrorism without unlawfully infringing on human rights? As regards all these topics, I think the overarching question for us at ODIHR is also how can ODIHR further assist OSCE participating states in protecting human rights in all these areas. We already have a very long list of speakers, so I will have to be quite strict in keeping time. I would also like to encourage all of you, HEM participants, to submit either soft or hard copies of your statement to the documentation center at the venue main lobby for distribution, so that the flow of document accurately reflects the flow of discussions during the plenary session. And I would also like to remind you about the possibility to submit written recommendations that will be compiled in the consolidated summary of the Human Dimension Implementation meeting after the meeting. We have, as you see, Twitter on screen, and I would also like to encourage and remind you of the possibility to contribute to the ongoing OSCE United in Countering Violent Extremism campaign by sharing views using the campaign hashtag UnitedCVE. And in this connection, I would also like to announce that for those of you who are interested in showing your support to the campaign by having a photograph taken of you, There are opportunities to do so straight after this session at 1 p.m. and then later on at 3 p.m. With this, I would like to introduce, to move on to the introduction of our introducer. We are very happy to have with us today Mr. Jens Modvig from Denmark. He is the Director of Dignity, the Danish Institute Against Torture, a clinical associate professor at the University of Copenhagen, and a member of the United Nations Committee Against Torture. Mr. Modvig's prior assignments include being the director of the UN office in Belgrade, the deputy head of mission of the OSCE, deputy head of missions of the OSCE mission in Kosovo, and the Secretary General of the International Rehabilitation Council for Torture Victims. Since 2009, Mr. Modvig has been a member of the Advisory Board of Torture, a journal on rehabilitation of torture victims and prevention of torture, and a participant in the build-up and implementation of the Danish National Preventive Mechanism under the OPCAT to the UN Convention Against Torture. He's the author of several publications covering torture, sexual abuse in prisons, torture and refugees, and Mr. Modvig holds a PhD in public health epidemiology from the University of Copenhagen. I know that before his introduction, Mr. Modvig would like us to watch a video that will sort of be, to which he will be referring to in his introduction. So I would kindly ask my colleagues to dim the light. Please be advised that we will be dimming the light to be able to watch the video more comfortably. And also please be advised that the video is somewhat strong in its content, but we hope it will serve as a good basis to stimulate further discussion. Thank you. Thank you. And Mr. Modvig, the floor is yours.
Thank you, Omar. Excellencies, ladies and gentlemen, when discussing the human rights violation of torture, it's important not to forget the human being who was subjected to torture. Victims or survivors of torture most often have had their lives ruined because of the physical, mental, and social consequences of torture. Often, victims will not even seek assistance or treatment because it's too painful to even think of the torture, and the torture is better ignored or neglected to reduce the suffering. As we saw in the video, support from the general population is of great importance to ensure and strengthen the eradication of torture as well as the provision of rights to the victims of torture. The rule of law, the headline of this working session, is the legal principle that law should govern a nation as opposed to being governed by arbitrary decisions of individual government officials. Implementing rule of law in a human rights context may be seen as entailing 3 steps, namely establishing the law in alignment with international human rights standards, establishing the enforcement of the law with due respect to protection of individuals from human rights violations, and establishing accountability, notably scrutiny, by independent bodies. In connection with the absolute prohibition of torture, the United Nations Convention Against Torture, to which all OSCE participating states are states parties, provides prescriptions at all the three levels: which domestic legislation to enact, standards for the enforcement of the law, and also accountability by independent bodies. The latter is obviously even more detailed in the optional protocol to the Convention Against Torture. This framework, the United Nations Convention Against Torture, served to protect citizens against violations of basic human rights, including rights in connection with deprivation of liberty. The legal measures to be taken at the domestic level involves including in the law a definition of the crime of torture in accordance with the international definition in the UNCAT, and ensuring that this crime is punishable by law. The law also needs to provide people deprived of their liberty with basic rights, safeguards, including the right to see a lawyer from the onset of the arrest, the right to see a medical doctor at his or her own choice, and the right to inform family or relatives of the arrest and the whereabouts of the detainee. In this connection is also included the habeas corpus, that is, the right of a judicial review of the legality of the deprivation of liberty. Finally, the right to redress, including rehabilitation of victims, should be present in the national legislation to ensure that victims of torture receive reparation. In terms of enforcement of the law enforcement agencies need to operate by standards ensuring compliance with respect for human rights. According to Article 10 in the UN Convention Against Torture, state parties are obliged to provide training of law enforcement personnel and other staff involved with detained persons. The training must include the prohibition against torture and ill treatment. The accountability, including independent scrutiny, is inter alia represented in the Convention's Article 11, according to which state parties shall keep under systematic review interrogation rules, instructions, methods, and practices, as well as arrangements for the custody and treatment of persons subjected to any form of arrest, detention, or imprisonment, with a view to preventing any case of torture. However, this is even clearer in the OPCAT, which inter alia establishes a scrutiny mechanism, the National Preventive Mechanism, to monitor conditions, procedures, and practices in all places where people can or are deprived of their liberty. In conclusion, the United Nations Convention Against Torture and its optional protocol provides a valuable and comprehensive framework for the establishment and maintenance of rule of law, not only for the prevention of torture, but also for a more general protection of the population against human rights violations by the law enforcement agencies. In 2009, the OSCE published a report, The Fight Against Torture, the OSCE Experience. The report established the OSCE framework for the fight against torture, notably the Copenhagen document and the Istanbul Charter of 1999, where participating states committed themselves to the eradication of torture and other cruel, inhuman, or degrading treatment or punishment. But more importantly, this report was based on a survey among the then 18 OSCE field missions. While it was clear that the field operations were actively involved in torture prevention, the study identified a comprehensive list of obstacles to the prevention of torture, comprising systemic, conceptual, and resource problems. A few of these should be mentioned here. A lack of political will on part of governments and a low priority for human rights issues in general. Corruption in various sectors of the legal system. A lack of public awareness of persons' rights in relation to torture. The presumption of guilt by public and justice officials with regard to arrested people, leading to tolerance for torture. A weak or non-existing NGO community. And overcrowding in prisons and a lack of financial resources, leading to poor conditions for those in detention. The study also identified problems relating to legislation and the functioning of the legal system, of which a selected few are mentioned here. The non-existence of or failure to implement legislative fair trial safeguards, such as access to lawyers and doctors, limits on pretrial detention periods, and related guarantees. Absence of torture as an offense in national criminal legislation. The absence of interrogation procedures that tend to safeguard against torture. And the failure to investigate allegations of torture promptly and impartially. It is clear from this problem identification that there's a great need to implement the provisions in the Convention Against Torture, provisions that participating states have already embraced by ratifying the Convention. A challenging question is what the OSCE can do to strengthen the implementation of the Convention and thereby overcome the obstacles for prevention of torture identified in the report. In connection with efforts by the United Nations to strengthen its treaty bodies, including the Committee Against Torture, adopted by the General Assembly in 2014, the committee has very recently strengthened its follow-up of the concluding observations which emerge from consideration of periodic reports from its states parties. The strengthened follow-up procedure now includes an encouragement to provide to the committee, within 1 year, a plan for the implementation of the recommendations made by the committee in its concluding observations. These recommendations will mostly take the nature of enacting legislation according to international standards, as mentioned above, implementing such legislation in practice, and ensuring accountability mechanisms to ensure consistent compliance with these standards. The OSCE field missions could play an important role for the follow-up of CAT recommendations and assist governments in doing so in preparing a plan for the implementation of the CAT recommendations. This would introduce a direct and strong synergy between the United Nations treaty body system and the strong field presence of the OSCE. The OSCE field operations are very well placed to take on this role, both in terms of the capacity of the field mission staff, as well as in terms of a close and confident working relationship with the governments. The governments of Chile, Denmark, Ghana, Indonesia, and Morocco recently have taken an important initiative called the Convention Against Torture Initiative, or CTI, aiming for universal ratification and implementation of the Torture Convention during the next 10 years. The initiative also includes working for the ratification of the optional protocol. Within the OSCE region, all participating states, as mentioned, have ratified the convention, so one challenge here is its full implementation. Another challenge is the ratification of the OPCAT, where currently still some 16 countries have not yet ratified this important torture prevention tool. OSCE might consider making it a substantial strategic priority to support this initiative by making the implementation of the Convention Against Torture in the OSCE region one of its main priorities for the coming decade. Such a priority might entail a number of activities for the field missions. Assist the government with the timely preparation and submission of periodic reports to the Committee Against Torture. Enable civil society to prepare and submit shadow reports to the official periodic report. Support the establishment of rehabilitation services responding to the needs of the victims of torture. Assist the government in close follow-up of the CAT concluding observations, including the preparation and submission of an implementation plan for all of the recommendations made by the committee. Support campaigns to increase the awareness in the general population of torture, the prohibition of torture, and the need to prevent and eradicate torture. And provide and coordinate technical assistance in the implementation of the plans submitted to CAT. A focused effort on part of the OSCE in close collaboration with the participating states and the UN Committee Against Torture to implement the CAT recommendations would almost certainly contribute to an increase of the rule of law, including the prevention of torture in the OSCE region. Thank you very much.
Thank you very much, Mr. Modvik, for this interesting presentation and also some very concrete recommendations for us as the OSCE as to potential future area of work in assisting participating states in the fight against torture. I am informed that we have a very long list of speakers, which we will need to close soon, just to leave enough time for statements by everyone. So if any of you is interested in making a statement, please approach my colleagues now. We still have space for a very small number of speakers, but we will need to close the list very, very soon. With this, I would now like to open the floor to the interventions in my list of speakers. And the first one is from Denmark on behalf of the EU. Denmark, you have the floor. Thanks.
Thank you very much. I am honored to speak on behalf of the European Union. The statement is made also on behalf of Turkey, former Yugoslav Republic of Macedonia, Montenegro, Albania, Bosnia and Herzegovina, Liechtenstein, Norway, the Ukraine, and Andorra. The rule of law is one of the fundamental principles on which the EU is founded. It is a principle of governance to regulate the exercise of public power. A key objective for the EU is to strengthen the rule of law both at international, regional, and national levels. The EU recommends all states who still practice the death penalty or retain it in law to abolish it. Likewise, the EU strongly calls on all states not to reintroduce the death penalty once it has been abolished. The EU strongly and unequivocally opposes the death penalty at all times and in all circumstances, even when backed by due process in a democratic society. The cruel, inhuman, and degrading aspects of the death penalty are not mitigated by a democratic process. Any miscarriages of justice could lead to the killing by state authorities of an innocent person. We are encouraged by the growing momentum towards abolition worldwide, both in law and in practice. To date, all but 6 OSCE participating states have abolished the death penalty, 4 of which are de facto abolitionists. We encourage Belarus and the United States to follow the global trend towards abolition. As a first step towards abolition, the EU advocates a global moratorium on the use of the death penalty. We strongly encourage participating states to support the 2016 United Nations General Assembly resolution on this topic. Torture and ill treatment are among the most abhorrent violations of human rights and dignity and should be eradicated. The absolute prohibition of torture and ill treatment allows for no exception. In the fight against torture, the EU recommends that a full toolbox of measures be applied. Combating torture requires an integrated approach encompassing prevention, redress, rehabilitation, and access to justice. The EU supports the Convention Against Torture initiative and its efforts to achieve global ratification and implementation of the UN Convention Against Torture by the year 2024. The EU urges all OSCE participating states to contribute to the achievement of this goal by implementing fully the UN Convention Against Torture, and to give strong consideration to ratifying all international conventions and protocols on torture, the death penalty, and enforced disappearances. Independent national preventive mechanisms monitoring conditions of people deprived of their liberty are a particularly important preventive tool. The EU therefore encourages all states to establish or strengthen such mechanisms in line with the optional protocol to the Convention Against Torture. The persistent occurrence of torture and ill treatment, including in some OSCE participating states, is of grave concern to the EU. The EU strongly supports the Serbian chairmanship in resuming the work on the issue of torture. We hope consensus can be reached on a strong ministerial decision on this issue. We strongly encourage continued focus on eradicating torture in the OSCE's work, including with ODIHR and the OSCE field missions. Together, we must continue to work towards making torture a thing of the past. The scourge of terrorism affects all regions of the world. The EU is convinced that human rights protection and the fight against terrorism should be seen as complementary rather than contradictory. The EU's approach is to promote respect for the rule of law, fundamental rights and freedoms, as well as the use of the criminal justice system to prevent and combat terrorism. We commend the efforts of the OSCE in providing support to states to ensure respect for human rights in countering terrorism, and believe these efforts should be expanded further. A full statement will be circulated. Thank you, Mr. Moderator.
Thank you very much. I have not said that before, but I need to remind you that we have to limit statements to 3 minutes only, because we have, as I said, a very long list of speakers. So, and I will have to be rather strict in keeping the time. So apologies in advance for that. And I would now like to give the floor to our next speaker, the Center for Civil Liberties. You have the floor.
Здравствуйте. Good morning. I represent a coalition of civil society organizations in the human rights area. We are carrying out our work, or have been carrying out our work, in the Donbass since that time that the Russian army invaded Crimea and began an armed conflict, that is, a war in a number of regions of Ukraine. In March of 2014, President of Russia made an address to the Federation Council. On that very day, publicly, there was a statement of the aggressor to begin military operations in the territory of Ukraine. The support of Russia in the Donbass territory created illegal armed formations. These were used by the former regime in repressing Euromaidan. There was a repression against all protests. Activists were beaten, as well as were independent journalists. Later, they began to take over institutions of local authority, just as had been done in Crimea. Further, in the territory that they controlled, they introduced a regime of terror. They began to persecute large groups of citizens who were in favor of the state sovereignty of Ukraine. We have received information about 71 areas where there were prisoners taken. They were held in a number of different areas, in hospitals, in schools, and other places. The conditions of their detention were horrible. Men and women were mixed together. They were refused the use of toilets. They were unable to see their family members, and they did not receive any medical attention. This is systemic torture of a general character. They were beaten, and they were deprived of water. They were detained under horrible conditions and the treatment of women who were subject to torture. These cases are clear. In one case, a pregnant woman lost her child. In the so-called LPR and DPR, there is an organized system of kidnapping of civilians. This is, of course, a crime against humanity. Thank you.
Thank you very much. Next speaker on my list is Switzerland. Switzerland, you have the floor.
Merci. Thank you, moderator. The continuing existence of cases of torture and other cruel, inhuman, or degrading punishments or treatments in OSCE participating states, as well as the imperfect implementation of obligations foreseen by the Convention Against Torture and its OPCAT and commitments taken within the framework of the OSCE are cause for very grave concern. Switzerland remains convinced that it is necessary to strengthen the mobilization of the OSCE to promote the combating of torture, and will continue, therefore, to extend strong support to the organization in this field. Combating torture, and in particular the prevention of torture, will also be one of the priorities that Switzerland has set for itself for the year of its chairpersonship in office. The various discussions organized last year have shown that the strategic position of the OSCE makes it possible for it to extend its support to improve the implementation of international commitments thanks to the specific instruments that it offers. The OSCE is in a position to give added value to constant efforts undertaken in this regard, and thus it supports the participating states in the implementation of its commitments as well as in the development of national prevention mechanisms and contributes to better coordination among international organizations and other agents. The strengthening of the role of civil society is, of course, a very important aspect of this work, and in this respect, Switzerland welcomes the decision taken by the Serbian chairpersonship in office to keep the issue of torture prevention on the OSCE program for 2015 and to propose the adoption of a new ministerial decision. Switzerland also welcomes the positive operational measures being set up presently by the OSCE, such as the creation of a new position of advisor for the prevention of torture within the framework of ODIHR. Despite all of these efforts, it must not be forgotten that it is really up to states in the first place to make sure that the prohibition of torture is fully implemented and to improve the prevention of torture. And at this point, Switzerland would like to make two recommendations. First of all, we recommend OSCE commitments in the area of torture prevention be renewed and strengthened by the adoption of a new decision by the Ministerial Council in Belgrade. Second, we also recommend OSCE participating states that have not yet done so to ratify the OPCAT and to create an independent national prevention mechanism. Thank you for your attention.
Thank you very much. Next speaker on my list is the United States of America. You have the floor, please.
Thank you, Mr. Moderator. Since the OSCE HDIM in 2014, the United States appeared before the UN Committee Against Torture, where we engaged in an open and forthright discussion on the United States record on issues ranging from the police use of force to the wide scope of civil remedies for seeking redress in cases of torture, to the former CIA rendition detention and interrogation program. In December 2014, the U.S. Senate Select Committee on Intelligence released a declassified version of the executive summary of its report on the former CIA program, which contributed to a national conversation on this difficult period in American history. As President Obama has acknowledged, we crossed the line, we did not live up to our own values, and we take responsibility for that. We have since taken steps to clarify that the legal prohibition on torture applies everywhere and in all circumstances, and to ensure that the United States never resorts to use of those harsh interrogation techniques again. The United States is committed to protecting human rights while countering terrorism and violent extremism. During last February's White House summit to counter violent extremism, President Obama emphasized the necessity of independent judiciaries that uphold the rule of law, police and security forces that respect human rights, space for members of civil society groups and all individuals to exercise their human rights, including the freedom of expression, and freedom of religion to ensure lasting stability and security. At the current Human Rights Council session in Geneva, the United States supports a resolution on preventing and countering violent extremism. President Obama will be hosting a Leaders Summit on countering ISIL and violent extremism on September 29th in New York on the margins of the UN General Assembly. We are concerned, however, that laws against extremism are used in some participating states to repress political dissent, restrict free speech, or unduly restrict the peaceful exercise of religious freedom, such as in Russia. We are deeply concerned by reports of abuses by Russia-backed separatists in territories in eastern Ukraine, as well as by the so-called occupation authorities in Crimea. We condemn all abuses regardless of who commits them. We call on all sides to allow for full and transparent investigations into allegations of abuse of human rights. We're also deeply concerned about reports of the use of torture and other abuse against several Ukrainian hostages held by Russia. Reports of torture and other ill treatment by security forces and prison personnel of persons in detention in Uzbekistan continue. We support the OSCE training on prevention of torture that is conducted in Tashkent. We encourage the government of Uzbekistan to allow the International Committee of the Red Cross to resume prison visits. Turkmenistan continues to be unwilling to consistently allow family members or international observers access to its prison system. With respect to the cases of several dozen disappeared political prisoners, we urge the government to prove they are alive or provide basic information about their whereabouts. We are concerned by reports of abuse by police in Armenia during arrest, detention, and interrogation, and in Azerbaijan, reports of torture and other abuse of persons in custody continue. The United States respects the views of those who advocate for a moratorium on capital punishment, including many delegations around this table. The United States again emphasizes that capital punishment is not prohibited by international law when imposed in accordance with the state's international obligations, including the International Covenant on Civil and Political Rights. We will submit a full statement for the record. Thank you.
Thank you very much. Next speaker on my list is the Kharkiv Human Rights Group, followed by Norway. Kharkiv Human Rights Group, you have the floor.
Thank you, Mr. Moderator. Ladies and gentlemen, recent studies of illegal deprivation of liberty and the use of torture, cruel and inhuman treatment was realized in the coalition, by the Coalition Justice for Peace in Donbass with the cooperation with the Helsinki Foundation for Human Rights. We are talking about the cases of illegal detention, kidnapping and tortures of people in the zone of anti-terroristic operations. This short intervention is the announcement of today's side event, and I'd like to draw your attention to the presentation of the report with the analytical and concrete description of cruelty. The title of the report is The Surviving Hell, so it will speak about the person who survived the hell of the illegal detention. And on my side, one of the witnesses who will participate in this event, we will have the witnesses who will share the information during this event that will start from 18 this afternoon. The hard copy of the report will be proposed to all who will attend this side event. In 1945, Europe has said never again to the atrocity of and horrors of the war, to the killings, murders, tortures, persecutions. And at this time, the international mechanism, instruments and institutions were established, such as UN, Council of Europe, NATO, OSCE. Ukraine has become a member state of the Council of Europe in 1995 and introduced the jurisdiction of its instrument on whole territory. However, despite this, we may confirm that on Ukrainian territory in Crimea, in the occupied territory of the some parts of Donetsk and Lugansk regions, there is no rule of law territory. There is no rules. There is no law. It's gray zone of gray law. The area without any mechanism of justice. The main purpose of this study mentioned by me was that we will present to your attention what is found out and the records of the cases of torture and illegal treatment in order to pursue the perpetrators and bring them to justice at national and international level. Why such brutality and cruelty occurred on the territory of this gray zone? Two main causes. First, one, the obvious intention to install the impressive regime with the demonstrative cruelty, to punish some to afraid all. Secondly, impunity of criminals. Classic rule of criminology. Unpunished crime provokes its repetition and became more cruel. In the precondition that never again, it should be never again 8,000 people killed during the last year in Ukraine and more than 18,000 people wounded. Never again of Boeing 777 with the flight MH370. Never again unpunished torture and life in the hell of the fire. Unpunished evil creates new evil. And we have to keep our eyes open, as it was mentioned in this film at the beginning of the session. Thank you.
Thank you very much. Next speaker is Norway, followed by the Russian Federation. Norway, you have the floor.
Thank you, Mr. Moderator. This is a statement on behalf of France, the Netherlands, Switzerland, and Norway. This morning, France, the Netherlands, Switzerland, and Norway co-organized a side event on enforced disappearances in the OSCE region, and it was also co-sponsored by the European Union, Iceland, and Bosnia-Herzegovina. Given the importance of this topic for our organization, we would like to share with you the following main conclusions. Enforced disappearance is not only a practice of the past in the OSCE area, it still continues to occur. It is not only directed against the disappeared persons, but equally harm their relatives and the whole society they live in. It often leads to torture and other ill treatment and is closely interlinked with arbitrary detention and extrajudicial killings. It has been, or it is, an integral part of strategies aiming at spreading terror within the society. Such disappearances, which go both unsolved and unpunished, constitute serious violations of human rights of the victims themselves as well as their families, against which the participating states have an obligation to fight and to provide effective remedies in their domestic legal systems. The International Convention for the Protection of All Persons from Enforced Disappearance, which was adopted by consensus on 20th December 2006 by the UN General Assembly, is the effective response to this heinous scourge. It is one of the strongest human rights treaties ever adopted by the UN. It aims to prevent enforced disappearances taking place, uncover the truth when they do occur, punish the perpetrators, and provide reparations to the victims and their families. The Convention further sets forth the obligation of international cooperation, both in suppression of the practice and in dealing with humanitarian aspects related to the crime. To date, 37 participating states have signed and 18 have ratified it, which represents 5 additional OSCE participating states since last year. All OSCE participating states adopted the UN Declaration on the Protection of All Persons from Enforced Disappearance at the UN General Assembly in 1992. They inter alia committed not to practice, permit, or tolerate enforced disappearances, and to take effective legislative, administrative, judicial, or other measures to prevent and terminate acts of enforced disappearance in any territory under its jurisdiction. In Resolution 69/134, adopted by consensus last year at the UN General Assembly, they called upon states that have not yet done so to consider signing, ratifying, or acceding to the Convention for the Protection of All Persons from Enforced Disappearance as a matter of priority. The lack of specific OSCE commitment to prevent and combat the crime of enforced disappearance is a serious gap that should be addressed without delay. The topic of the prevention of torture, which is again on the agenda of the Ministerial Council this year, is an opportunity to close this gap. We trust that the OSCE participating states will assume their responsibility and adopt a strong Ministerial Council decision encompassing all relevant aspects of prevention of torture in the OSCE area, including enforced disappearance. It is high time we updated our human rights commitments in this regard in accordance with international obligations. Thank you, Mr. Moderator.
Thank you very much. I would like now to announce that the list of speakers is closing in 1 minute. Next speaker on my list is the Russian Federation, followed by the International Partnership for Human Rights. Russian Federation, you have the floor.
Mr. Moderator, dear colleagues, combating torture is a subject, of course, that we need to discuss very seriously and to make sure that we act in an effective and coordinated manner. We welcome the decision of the Serbian chairpersonship in office once again to put forward a draft decision to the Ministerial of the OSCE in Belgrade on this subject. This will call on working out a common approach within the framework of our organization to make sure that we act together to combat this infamous phenomenon. We are convinced that it is necessary once again to discuss this issue that it is still present, this flagrant violation of human rights, like the kidnapping or abduction of individuals in third countries without information being provided to their state of citizenship, keeping them incommunicado detention, submitting them to forced feeding. All of this has not been properly assessed within the framework of the OSCE. Instead of a direct criticism of these horrific practices, we see attempts on the part of our partners from the European Union to move the stress toward forced disappearances with an arbitrary definition of that term. And we believe that there should not be closing of borders to refugees who are fleeing places of armed conflict. This is not consistent with our human dimension principles. For our part, the Russian Federation is receiving refugees from Ukraine who are saving themselves from the so-called anti-terrorist operations of the Kiev authorities against the population of Donbass. In the period 2014-2015, the number of refugees coming to the territory of Russia from Ukraine is in excess of several million persons. In our work to provide normal living conditions for these refugees and refugees, we base ourselves on the rich experience of controlling migration flows that have been developed within the framework of the CIS. Now, the policy of sanctions introduced by certain countries within the OSCE are not acceptable, and we call upon our Western partners to move away from a dual standard when it comes to dealing with terrorism and extremism. And I must say that we remain bewildered by the practice of imposing changes in national legislation concerning monitoring of places of detention in order to prevent harsh treatment and the implementation of measures to combat torture under circumstances when the proposed measures are not proving their worth in many OSCE countries. Declarations that have been made about limiting access to places of detention by representatives of NGOs without taking into consideration the rights of accused and defendants, in particular their right to privacy, are not acceptable. And despite the fact that the OSCE has adopted a moratorium or recommended a moratorium on capital punishment, a number of countries have done this. We're very concerned by the practice of the United States of America, which continues to use untested medical substances that turn this punishment into cruel and painful torture. Violations of human rights must be subject to constant attention by the OSCE, and we confirm the commitment of the Russian Federation to the principles of international law and prepare for further cooperation.
Very much. Next speaker on my list is the International Partnership for Human Rights, followed by Azerbaijan. And I would like now to announce that the list of speakers is closed. International Partnership for Human Rights, you have the floor.
This statement is about torture in Kazakhstan, Kyrgyzstan, and Tajikistan. The NGO coalitions against torture in Kazakhstan, Kyrgyzstan, and Tajikistan, and the Civic Solidarity Platform members Helsinki Foundation for Human Rights in Poland and International Partnership for Human Rights in Belgium would like to commend the authorities of Kazakhstan, Kyrgyzstan, and Tajikistan for recently having pioneered several positive steps aimed at eradicating torture. We urge the authorities of each of these countries to take note of their neighbors' positive steps and follow their example in those areas where they have made more progress. We also call on the other OSCE participating states to reiterate this call in bilateral meetings and human rights dialogues. Kyrgyzstan and Tajikistan should follow Kazakhstan's example of having abolished the statute of limitations applicable to torture and of having excluded those charged or convicted of torture from amnesties. In addition, Kyrgyzstan and Tajikistan should significantly strengthen the legal safeguards accessible to detainees, as Kazakhstan did in its new criminal procedure code. Kazakhstan should follow recent steps taken by Kyrgyzstan's and Tajikistan's ministries of health. They obliged medical personnel, when conducting examinations of detainees, to document torture and other ill treatment in line with the principles contained in the UN's Istanbul Protocol. On the issue of compensation for moral damages resulting from torture, Kyrgyzstan should follow Kazakhstan's and Tajikistan's example. In these two countries, several torture victims or their families have received compensation from the state in recent years. The authorities of Kazakhstan and Kyrgyzstan are parties to the OPCAT, and national preventive mechanisms started functioning in 2014. Tajikistan should follow these countries' example. Despite these positive steps, torture and ill-treatment continue in all Central Asian countries, and impunity is the norm. Political will is needed to push for further improvements. Since the beginning of 2015, the NGO Coalition Against Torture in Kazakhstan registered 67 new cases of men, women, and children who alleged to have been subjected to torture and other ill treatment. In the same period, the NGO Coalition Against Torture in Kyrgyzstan registered over 98 cases, and the NGO Coalition Against Torture in Tajikistan registered 32 new cases. Finally, I would like to take this opportunity to invite you all to a side event on the implementation of the standards of the Istanbul Protocol in Kazakhstan, Kyrgyzstan, and Tajikistan that will take place at 1:30 today in the plenary hall. The full statement is available on the table outside the room. Thank you for your attention.
Thank you very much. Next speaker is Azerbaijan, followed by Penal Reform International Regional Office in Central Asia. Azerbaijan, you have the floor.
Thank you, Mr. Moderator. Ladies and gentlemen. As a result of democratic reforms carried out in the Republic of Azerbaijan, new progressive laws serving to more efficient protection of human rights were adopted. The country joined numerous significant conventions in the field of protection of human rights and liberties in order to propose relation of measures of human rights sphere, as well as UN Convention Against Torture, European Convention on Prevention of Torture, and relevant optional protocols to these conventions. Alongside, the Commissioner was determined as a national preventive mechanism against torture by the decree of the President of the Republic of Azerbaijan from January 2009. As a result of undertaken organizational measures, there was complete out the list of places of deprivation and restriction of liberty, as well as of penitentiary institutions, temporary detention places, and other relevant facilities in the country. Nowadays, the National Preventive Mechanism of Azerbaijan continues its activity in four main directions: preventive lists, preventive visits, legal analysis, legal enlightenment, public relations, and international cooperation. I would like to note that Ombudsman of Azerbaijan, as a national preventive mechanism, conducted 365 visits in 2014, the place that as persons can't leave their will. 267 planned visits and 98 ad hoc visits were conducted. The press release regarding these visits were sent to the mass media and placed on the official website of the Commissioner. The representative of Ombudsman regularly meet with the persons whose names were sounded here during the last 4 days: Leyla Yunus, Arif Yunus, Intigam Aliyev, Ilgar Mamadov, Anar Mehmetli, Rasul Jafarov, Farash Karimli, Murat Adilov, Hilal Mehmedov, Perviz Hashimli, Khadija Ismail, Tofik Yagublu, Rauf Mirgadirov, Seymour Hazi, Araz Guliyev, Nijat Aliyev, and others are among those, and several meetings were conducted with each of them on different times. During the conversation with the above-mentioned persons, they did not complain about the treatment towards them. As a result of the visit, the Ombudsman made appeals to the Prosecutor General, Minister of Justice, Chief of the Penitentiary Service, Head of the Medical Department, and other relevant governmental body regarding the investigation of the case of these persons' detention conditions, medical, social problems. Their conditions were kept under their attention. And finally, I would like to say, as a result of, as you know, Armenian aggression against Azerbaijan, fate of more than 4,000 Azerbaijan prisoners of war and hostage in the captivity of Armenia still remain unknown. inflicting brutal torture and degrading treatment against Sharpaz Guliyev and Dilgam Askarov, who visited the native land, and graves of their parents, murdering of Hassan Hassanov, targeting the civilians, including children, by the Armenian force through the contact line and Armenian-Azerbaijan border since the very beginning of occupations, and all the facts Armenians' immoral and inhuman policy determined to the international law. Thank you for your attention.
Thank you very much. Next speaker is Penal Reform International Regional Office in Central Asia, followed by Sandy Jan. Penal Reform International, you have the floor.
Thank you. Mr. Moderator, dear delegates, Penal Reform International, PRI, welcomes the opportunity to inform delegates of the conclusion of the revision of the UN Standard Minimum Rules for the Treatment of Prisoners, or SMRs, which constitutes a significant development in international standard setting for the rights of detainees and the prevention of torture. The SMRs, first adopted in 1955, are regarded as the primary, if not only, source of the standards relating to the treatment of detainees, and are the key framework used by monitoring and inspection mechanisms in assessing the treatment of prisoners. It is therefore particularly crucial that they are consistent with the current standards of human rights and criminal justice. 6 decades after their adoption, it was recognized that SMRs no longer reflected human rights norms and correctional science. Accordingly, 2010 United Nations General Assembly resolution mandated an intergovernmental expert group to revise the rules. The expert group employed a targeted revision approach which involved drafting new text for the most outdated rules. Consensus was reached by the expert group in Cape Town in March 2015, and the UN Crime Commission adopted the new text shortly after them in May and transmitted them to the Economic and Social Council for subsequent adoption by the General Assembly at the end of this year. The revised SMRs are to be known as the Mandela Rules, in honor of the legacy of Nelson Mandela, who spent decades imprisoned and suffered hunger, forced labor, and solitary confinement. To highlight 3 significant changes relating specifically to the prohibition of torture or ill treatment. First, the obligation to treat prisoners with respect for their inherent dignity and to refrain from torture or similar prohibited ill treatment or punishment is explicitly stated in Rule 1. Safety of prisoners and others within the institution, including staff and visitors at all times, must be ensured. Second, the use of solitary confinement, defined as separation from the general prison population for more than 22 hours without meaningful human contact, is now submitted to limitations. Indefinite and prolonged solitary confinement, i.e. in excess of 15 days, is now prohibited. Third, new rules provide guidance on conducting searches of prisoners and visitors. A part of prison regimes that often leads to humiliation and ill treatment, the rules require that searches are applied only when necessary and proportionate and respectful of human dignity. Particular restrictions apply to body cavity searches. These 3 illustrative safeguards are part of the reason that the revised standard minimum rules have been widely heralded as a momentous development for the some 10 million people imprisoned every day. The revised SMRs also constitute a significant development in that they reconcile criminal justice and human rights standards. They provide protection for persons deprived of their liberty and recognize their rights, but at the same time deliver the legal certainty to prison administrations by providing comprehensive, up-to-date guidance. Penal Reform International would therefore like to encourage states to implement the revised standard minimum rules and to use momentous revision up to date their national prison rules and the policies. For the text of the revised rules and more information on the process, I refer to PRI's website, penalreform.org, under the Global Advocacy section. Dear Moderator, due to the time frame, I couldn't deliver the statement on the capital punishment. However, it was submitted to the Recommendation Center. Thank you very much for your attention.
Thank you very much. Next speaker I have is Sandy Jan, followed by the Human Rights Center of Yasna. Sandy Jan, you have the floor.
Good afternoon, colleagues. Moderator, I represent a South Ossetian NGO, Sandyjan. Quite recently, we witnessed the mass seizure of citizens of South Ossetia by the security forces of Georgia, who tortured them, violated their rights, and there have been cases of disappearances of Ossetians. After 2008, such cases have decreased dramatically. because it became more difficult for the Georgian security forces to carry out operations in South Ossetia. However, there are serious problems remaining with Ossetian prisoners who have been in Georgian prisons for many years. To be fair, after Saakashvili left, the situation did improve. However, even today, there are serious problems. In the spring of this year, citizens of South Ossetia, Georgi Zasev, Georgi Valiev, and Yusuf Kochev carried out a hunger strike in the sadly well-known Gladansk prison as a way of protesting their conditions and the violation of their rights. I'd like to recall that these citizens were kidnapped by the security forces of Georgia in the territory of South Ossetia in 2005 on false charges of having participated in the organization of terrorist acts in the city of Gori, and they were sentenced to life in prison. Now, this crime, in fact, was confessed to by a Georgian citizen who was born in Gori, Merab Chochishvili, and he was in a very difficult psychological situation. He said that he was avenging the police for the death of his son. He, in fact, was held by the Georgian police, and his son was, and died in prison. Mr. Chochishvili was put in a psychiatric clinic, and the police accused him of the South Ossetians of the crime that he had in fact committed. Now, today, the issue of South Ossetian citizens in Georgian prisons is a sad result of Saakashvili's rule and an obstacle to Georgian-Ossetian dialogue. In order for the Georgian authorities to carry out this dialogue, they must solve the issues that I have mentioned. Thank you.
Thank you very much. Next speaker is Human Rights Center Viasna, followed by the Office for Civil Freedoms. Human Rights Center Viasna, you have the floor.
Good morning. Despite the decrease in capital punishment in Belarus since 1999, Belarus continues to apply capital punishment and is, in fact, the last country in Europe and in the post-Soviet area that uses capital punishment. It has been applied this year. Information on the use of capital punishment in Belarus is considered national security and is a secret and not provided to the citizens. Official media and authorities act in contradiction to the commitments that the country has taken in the OSCE. In the country since 1991, roughly 400 people have been received the death penalty. Any information on this, as I said, is considered a state secret. And information is not provided, nor is the body of the person who has been subjected to capital punishment provided to the families. The UN committee that back in 1999 examined an appeal against the Belarus authorities has issued recommendations which were not implemented. And the corresponding changes that were recommended to the legal code of Belarus were not instituted. Since the breakup of the Soviet Union, we can consider that there has not been a serious discussion in Belarus of eradicating the death penalty. The situation in neighboring Lithuania is quite different. I'd like to draw your attention as well to constant violations of the Republic of Belarus of international human rights standards as enshrined in UN documents. In fact, there are procedural issues in death penalty cases in Belarus. And again, this is in violation of UN human rights standards. It should also be noted that currently the UN Human Rights Commission is examining 5 specific cases of the use of the death penalty in Belarus in violation of international norms. We believe that a moratorium on the death penalty in Belarus will be the first step to fully abolishing it. Thank you.
Thank you very much. My next speaker is the Office for Civil Freedoms, followed by the Office Attorney at Law, Ayman Umarova. Office for Civil Freedoms, you have the floor.
Good day. The NGO Coalition to Combat Torture in Kazakhstan, Kyrgyzstan, and Tajikistan, and also members of the International Civil Solidarity Platform, the Helsinki Fund on Human Rights, and the International Partnership on Human Rights are seriously concerned by the fact that the armed forces in Tajikistan are continuing to apply torture, which sometimes has very dire consequences indeed. Since the beginning of 2014, 6 soldiers have died, 5 of them having served in the border guards under the State Committee for National Security of Tajikistan, and 1 of them served in the army. Since January of 2014, the NGO Coalition to Combat Torture in Tajikistan has identified a total of 12 cases of applying torture and other forms of cruel treatment in the armed forces. But these 12 cases only represent the tip of the iceberg, because victims and their families often do not complain because they are afraid of repression and being labeled traitors by their fellow soldiers and their officers. One of the victims was Abduvakov Kayumov, who was so seriously beaten by 2 fellow soldiers with a wooden club that he died on the way to hospital in July of 2015. Shakhbolu Mirzoyev, a border guard soldier, was beaten so seriously in March of 2014 that he became an invalid, and now he's in a position to sit in an invalid's chair for a maximum of 2 hours per day. The rest of the time, 22 hours per day, he has to lie down. We're concerned by the fact that not all investigations carried out by the Military Prosecutor's Office are effective. Officers have been identified as liable in only 3 of these cases, although there is strong evidence on the basis of which one could assume that senior officers are responsible for the fact that they did not prevent violence being exercised against soldiers. We're also concerned by the fact that in 2014, in the case of at least 3 officers identified as guilty, amnesty has been applied and their period of detention has been shortened. Our main recommendations, therefore, to the authorities of Tajikistan are the following: to publish complete statistical data about complaints, legal proceedings, and accusations connected with torture and other forms of cruel treatment in the army, to ensure that amnesty is not applied to these guilty persons, and to introduce immediate investigations on all facts of such charges, and to make sure that the guilty parties are brought to criminal liability. Thank you for your attention.
Thank you very much. Next speaker is the Office Attorney at Law, Umarova Ayman, followed by the Kazakhstan International Bureau for Human Rights and the Rule of Law. Office of the Attorney at Law, Ayman Umarova, you have the floor.
Уважаемые присутствующие.
Distinguished colleagues, Kazakhstan is fighting against torture. Yes, there have been some achievements in this area, but I'd like to refer to the official data that NGOs refer to, that the government refers to. They are not actually in keeping with the real situation. Why? Because this data comes from statistics that belong to the prosecutor's office, or that come from people, or refer to people that have appealed to NGOs. But the fact is that people do not come forward and talk about cases of torture. Why is this? Well, first of all, it's because if someone is being held, that person worries that if they do complain, they will be subject to further punishment and put in the sweatbox. Or there are threats on the part of law enforcement authorities. That is, if the person does make an appeal, then the person is accused of having committed more serious crimes. And a third reason is that there are threats by law enforcement staff towards the person's friends or a family. And in fact, for each criminal case, if not for each case, it is true that torture is used. In fact, but the people who are victims of torture are so afraid that they ask that those who are working with them do not talk about this. Let me say that there is an understanding of the reasons that torture is used in Kazakhstan. One reason is to receive confessions, and also in order to create a climate of fear. One big problem today is when this takes place within the framework of the law. Now, I referred to a punishment room or sweatbox. This is a 2 by 3 meter concrete room, and their bed is only available at 10 p.m. In the disciplinary isolation room, there is a large group of people held at 40 degrees Celsius. The conditions are very difficult. Now, there has been mass torture practiced in Kazakhstan. When there was unrest in the country, there was a mass seizure of citizens and accusations that were ungrounded. The prosecutor did not react to the cases of torture that were alleged in that situation. Now, one glaring fact of the violation of rights is the new criminal code. A lawyer cannot, under this new code, appeal for the correction of cases of torture. Thank you.
Is the Kazakhstan International Bureau for Human Rights and the Rule of Law, followed by Amnesty International. Kazakhstan International Bureau for Human Rights and Rule of Law, you have the floor.
Ladies and gentlemen, I'd like to welcome all of you here. The NGO Coalition to Combat Torture in Kazakhstan, Kyrgyzstan, and Tajikistan, and also the members of the International Civil Solidarity Platform, the Helsinki Fund on Human Rights of Poland, and the International Partnership on Human Rights of Belgium are concerned that Kazakhstan is not implementing decisions taken by the UN Committee to Combat Torture and the UN Committee on Human Rights when it comes to cases of torture victims within the framework of individual complaint procedures of these committees. The refusal to investigate is a violation of Kazakhstan's obligations to the UN. We believe that there should be an institute, and this has been decided, that would make it possible to investigate individual cases. And we appeal to the authorities of Kazakhstan to set up such a mechanism in the very near future. Over the last few years, the treaty bodies of the UN have drawn attention to the fact that Kazakhstan has violated its international obligations to prevent and not to allow for torture in certain cases. And up until now, Kazakhstan has partially fulfilled the recommendations of these bodies on 2 cases. In both cases, victims were provided with a compensation for moral suffering, but that was not sufficient. Apart from that, the perpetrators of these crimes have not been brought to court. In 2 other cases, Kazakhstan has decided to forcibly return Arshidin Israel and Hayriro Tursunov to China and to Uzbekistan, respectively. Although the UN has called on Kazakhstan not to do this because they would be in danger in their native countries. In its decision of November 2013 on Oleg Yevloyev, the committee has called on Kazakhstan to carry out an effective investigation to identify the perpetrators and to provide full compensation and rehabilitation, but that decision has not been implemented by the authorities. Thank you for your attention.
The next speaker is Amnesty International, followed by the Bureau on Human Rights and Rule of Law of Tajikistan. Amnesty International, you have the floor.
Chair, delegates, participants. The International Partnership on Human Rights, Amnesty International, the Association for Human Rights in Central Asia, the Civic Solidarity Platform and Human Rights Watch are concerned that torture and ill-treatment have effectively become an integral part of the criminal justice system in Uzbekistan and are central to how the authorities deal with criticism and dissent, combat actual or perceived security threats, and repress political opponents. Police and secret police use torture and other ill-treatment to extract confessions and incriminating information and to intimidate and punish detainees and their families. Those at particular risk include individuals the authorities perceive as a threat to national security, such as those who practice their faith outside state-approved mosques and those who are members or suspected members of banned Islamist groups. A flawed justice system continues to prevail in Uzbekistan. Courts continue to rely heavily on confessions extracted under torture, duress, or deception. Judges ignore or dismiss allegations of torture or other ill-treatment, even when presented with credible evidence in court. The lack of independence of the judiciary and of an independent mechanism for investigations of allegations of torture result in impunity for many state actors responsible for human rights violations, including torture. The practice of arbitrarily extending prison terms based on unsubstantiated allegations of disobedience of prison rules under Article 221 of the Criminal Code leads to many prisoners serving de facto life sentences with no hope of release in cruel, inhuman, and degrading conditions, often amounting to torture. For example, the original 9-year sentence of former Member of Parliament Murad Jorayev has been extended 4 times for alleged violations of prison rules. He has now spent 21 years in prison. He is scheduled to be released in November this year if his sentence is not extended again. Uzbekistan has no independent monitoring mechanism for all places of detention, and the authorities have refused to open their country to effective, independent international human rights scrutiny. Currently, there are 13 pending requests for country visits by the special procedures of the UN Human Rights Council, including the Special Rapporteur on Torture. We urge the government of Uzbekistan to immediately and publicly condemn the use of torture and other ill-treatment and issue an immediate invitation to the UN Special Rapporteur on Torture to undertake a fact-finding visit. We call on all other OSCE member states as a matter of priority to urge Uzbekistan to stop the practice of torture and to permit UN special procedures to visit Uzbekistan. Thank you.
Thank you very much. The next speaker on my list is the Bureau on Human Rights and Rule of Law of Tajikistan, followed by Set My People Free. Bureau on Human Rights and Rule of Law of Tajikistan, you have the floor.
Good day, distinguished colleagues. The coalition of NGOs against torture in Kazakhstan, Kyrgyzstan, and Tajikistan, as well as members of the International Platform of Civilian Solidarity and the Helsinki Fund on Human Rights and the International Partnership on Human Rights, are concerned that the authorities of Tajikistan do not provide torture victims and their families with access to compensation. In 2014, the families of Safanrali Sangov and Bakhmuridin Shodiev, who died in prison in 2010 and 2011, were the first cases in which torture was admitted, and a decision was made to compensate these families for moral damages. This was a constructive step, but we are concerned about the scale of the compensations which were decided upon by civil courts, and they were insufficient. The parents of Nazamidin Hamidov, who died in prison under suspicious circumstances in 2014, received compensation of something like €710 in July of 2015. The family of Safan Ralisangov and Bakhmuddin Shodiev received compensation on the order of €6,600 in 2015. Regarding the case of Shakhbul Mirzoev, who was so severely tortured in 2014 that he is paralyzed, the judges decided on compensation of €2,900 in May of 2014. But in August of this year, the War College of the High Court redirected, or rather repealed, the decision, and it is being examined now by a military court in Dushanbe. Now, although there was an order for the Tajik authorities to pay all of the medical costs, this has not happened in practice. As far as we know, there are other kinds of compensation which are not accessible to those who have suffered torture in Tajikistan. And we have, as a coalition of NGOs, been using our own resources in order to provide a rehabilitation program. Our recommendations to the authorities of Tajikistan are to provide fair and just compensation to victims of torture for moral damages, and to provide full rehabilitation to them, and to publish full statistical data on all cases in which there has been compensation for a moral and material harm due to the use of torture or degrading forms of punishment. We also believe that there should be more information from the courts about compensation to victims of torture. Thank you.
Thank you very much. Next speaker is Set My People Free, followed by the Action by Christians Against Torture. Set My People Free, you have the floor.
Kamal Fahmi, Set My People Free. About torture. Returning jihadists to the OSCE, we cannot receive them with open arms. Their victims demand justice. I think this is very important, to give a lesson so people not continue to torture. Capital punishment. I would like to add to abolishing capital punishment, to the abolishing of honor killing, unlike the killing of Charlie Hebdo and many women, and also the killing of alive-born babies in the Organization of Security and Cooperation in Europe, participating countries. Terrorism. To end Islamic radicalism and terrorism, start with ending apostasy and blasphemy laws in Islam. And it is in many countries illegal or lead to death sentence. There is no social justice without freedom of thought, conscience, and belief, and freedom to change belief. There is no end of intolerance in Islamic State without giving ex-Muslims and non-Muslims their basic political and civil rights. There will be no end to international terrorism and jihad without ex-Muslims and non-Muslims having their political and social freedom and equality in Islamic State, which is their homeland. There is no justification for terrorism. We should never, never justify the perpetrator of terrorist act. Murder of the innocent cannot be justified. It is a crime. This does not help to eliminate terrorism, to find justification for terrorist attack. Our focus should be to bring justice for the victims, and condemn the atrocities.
Thank you very much. Next speaker I have is Action by Christians Against Torture, followed by the Youth Human Rights Group. Action by Christians Against Torture, you have the floor.
Добрый день, уважаемые участники.
Good day, ladies and gentlemen. I'm going to talk about the problem of detainees in Kyrgyzstan who aren't given access to their fundamental guarantees. The coalition of NGOs against torture in Kazakhstan, Kyrgyzstan, and Tajikistan, and also the members of the International Civil Solidarity Platform, the Helsinki Fund on Human Rights, and the International Partnership on Human Rights are concerned by the fact that detainees in Kyrgyzstan are deprived of access to fundamental guarantees when they are under arrest or detained. Most attempts to commit torture, as we are informed, as the coalition is informed, occur when the detainee is in complete isolation, incommunicado, in a basement, in a vehicle of the militia or the office of a militia, sometimes for several hours and sometimes even for several days. In its closing comments of 2014 addressed to Kyrgyzstan, the UN Committee on Human Rights expressed its concern about the non-respect of fundamental guarantees regarding all individuals who are detained, the fact that they are not registered as detainees immediately after detention, lack of access to a lawyer of their choice, lack of a medical examination upon detention, and lack of access to medical care. In accordance with its criminal procedure code, in Kyrgyzstan, an individual who is detained is detained once brought to a place of detention, but it isn't stated how long that can take. So in that empty period, the individual is not provided fundamental guarantees until brought to a place of detention and recorded as such. In practice, in many cases, lawyers are not present at the time of questioning. Often detainees first meet with their lawyer at the time of a trial, which is supposed to take place within, or meeting a judge, which is take place within 48 hours of detention. Family members are not immediately informed upon detention, and sometimes they are not even informed after the end of the 12-hour period that is provided for in the legislation. The police often calls people in as witnesses or simply calls them in for a conversation, and in such cases there is no registration of the presence of the person at a place of detention, and this is not in accordance with national legislation. Our main recommendations to the Kyrgyzstan authorities are the following: to change the decision of deprivation of liberty in the national legislation to bring it in line with the standards of international law, and in particular to guarantee that the moment of actual detention is perceived as the beginning of detention, or is identified as the beginning of detention, to guarantee that an individual deprived of liberty would have the fundamental guarantees afforded, such as access to a lawyer of his choice, information of the detainee's rights, information of family members, and also access to an independent physician. Thank you for your attention.
The speaker who has just spoken is a representative of the Youth Human Rights Group, and that the Action by Christians Against Torture hasn't had the chance to deliver their statement. Is this correct?
Yes, that's correct.
So then I would kindly invite the Action by Christians Against Torture to deliver their statement, followed then by the Committee Against Torture. You have the floor.
Thanks a lot. Excellencies, ladies and gentlemen, dear colleagues, my name is Nordine Drissi. I'm representing a French-based NGO, ACAT, Action by Christians for the Abolition of Torture. ACAT has been working for more than 40 years on the prevention and repression of torture by supporting victims, families, lawyers, and human rights defenders by documenting the practice of torture worldwide, producing reports and analysis, and litigating torture cases and strongly advocating against this practice. OSCE comprises 57 participating states, all parties to the UN Convention Against Torture, thus committing themselves to prohibit the practice of torture. 62 states have designated national prevention mechanisms, NPMs, among them 39 are located in OSCE countries. NPMs are for sure an essential tool to fight against torture. But this is not the only avenue to work on the prevention of torture and against impunity of torturers. In that perspective, universal jurisdiction is a fundamental tool to prevent for impunity from acts of torture. It's a real deterrent against impunity. While it is preferable to prosecute those responsible for these crimes in the country where the crimes occurred, justice is not always possible there. National courts may be unable to provide justice, and states may also show unwillingness to prosecute perpetrators and use their legal system to shield the accused from justice. Universal jurisdiction allows national courts to try those who have committed torture in other countries. Since Augusto Pinochet's arrest in the United Kingdom in 1998, universal jurisdictions are further developed and is used by a number of OSCE countries, to name a few, such as Belgium, Canada, Denmark, Finland, France, Norway, Switzerland, United States, and others. Universal jurisdiction could nevertheless be under restrictions in national legislation, thus undermining the usefulness of this essential tool, like it's the case in Belgium, Spain, United Kingdom, and France. For instance, we're still astonished by the fact that the French international human rights policy is honoring a presumed Moroccan perpetrator of torture instead of prosecuting him. Torturers must not find a safe haven anywhere they go or when they flee their own countries. Strong political commitment is needed, and all of these are clear elements to create in all OSCE countries an environment conducive to fight impunity. In that perspective, ACAT urged all OSCE participating states to commit to the fight against impunity by setting up and implementing universal jurisdiction law and mechanism and provide adequate resources. ACAT recommends also OSCE and ODIHR in particular to advocate and promote universal jurisdiction to fight against torture. Thanks for your attention.
Thank you very much. The next speaker is the Committee Against Torture, followed by Serbia. Committee Against Torture, you have the floor.
Thank you, Mr. Moderator.
Now, in practice, the organization that I represent, the Committee for the Prevention of Torture, 90% of statements about torture are about torture when in police custody. So I'd like to talk about the reform of the police in this year. So the Russian Parliament has introduced this year a legislative draft which would significantly change the rights and responsibilities of the police. Now, currently, the Russian police are allowed to shoot to kill, with the exception of those women who show signs of pregnancy. Let me recall to you that the current law forbids shooting at women at all. So the new amendments actually would introduce the possibility to shoot to kill unless women show signs of pregnancy. The new, and I'd like to recall, as I've said, that women cannot be fired against currently. Now, there are a number of very dangerous trends that we see in the amendments that have been introduced. I'd like to recall that the main job of the police is to fight against any violations of the law under conditions that recognize the rights and freedoms of citizens. And this suggests that there's a presumption of trust of the police by the population. But the fact is that the police, in implementing their duties, do not always do so in keeping with the law. We are concerned that this approach of the new legislation can lead to a new wave of violence. The European Convention, or rather European Court on Human Rights, is full of cases of Russian citizens who have appealed against their treatment by the police. And we are concerned with the lack of access to investigations because a high percentage of the cases that we are dealing with show that investigations are incomplete. We suggest that these amendments may increase confrontation between the police and citizens, and we should like to draw the attention of the OSCE to this problem. Thank you.
Thank you very much. Next speaker is Serbia, followed by Kelim Shami, the Human Rights Protection Center. Serbia, you have the floor.
Thank you. Thank you for the opportunity to speak on the topic of the relevance for all participating states, namely fighting terrorism. I will be bringing a youth angle as a special representative of the Chairmanship in Office on Youth and Security and as a youth ambassador from Serbia. Having in mind that consecutive chairmanships of Switzerland and Serbia have prioritized youth on their agenda, this year Serbian CIO gave additional attention to violent extremism and radicalization leading to terrorism, recognizing the need of unwrapping youth angle and role in this context. Violent extremism and radicalization that lead to terrorism is a denial of democracy and of human rights, which are at the very core of the OSCE. Young people are recognized as especially vulnerable in this context, having in mind specifics of the age itself, new digital channels for recruitment used primarily by youth, and further risk factors such as belonging to marginalized communities, media portrayal of youth, multiple identities, and a variety of other factors. In this regard, a conference on countering violent radicalization, underlining work with youth and for youth, was organized in early September in Belgrade, gathering youth ambassadors, representatives of participating states, civil society, and experts, discussing the phenomenon through all three OSCE dimensions, including effective approach where countering radicalization and human rights protection are mutually reinforcing goals. In order to effectively commit to resolution of the violent extremism and radicalization, it is crucial to invest more in prevention measures targeting young people, while at the same time including them in shaping of such measures. Only cooperation and work toward mutual values of peace and stability can be fertile ground for a long-term change, and without participation of youth, protection of youth is not as certain. Comprehensive human rights education is one of the tools to tackle radicalization, but taking into account psychological factors behind sliding into destructive behaviors, emotional and social literacy are also areas of interest for early empowerment of new generations and for strengthening their capacity to make constructive choices for themselves and society in general. Protecting youth from violent radicalization and extremism and combating terrorism in general is a task for all participating states, asking for a multidimensional approach, involvement of all stakeholders in a society, cooperation and further research in order to develop feasible and effective prevention measures. OSCE-wide youth campaign countering violent radicalization may be the first step in this direction, which could foster cooperation and inclusion not only of youth, but other actors in all of our societies, as complex issues of this kind can be won only with all of our combined efforts. Thank you for your attention.
Thank you very much. Next speaker is Kelim Shami, Human Rights Protection Center, followed by the Public Foundation Golos Svobode. Kelim Shami, you have the floor. Oops, sorry.
Здравствуйте.
Good day. The Kelim Shami Human Rights Center has two subjects. I'll be very brief, and I'll start with some recommendations to the Republic of Kyrgyzstan, because the Republic should continue its judicial reform with a view to ensuring full independence and impartiality of judicial bodies, including the determination of objective criteria for selection and dismissal of judges. The Kyrgyz Republic should adopt measures to overcome shortcomings when it comes to procedural principles. There needs to be an end to this bureaucratic obstruction of torture cases. The Kyrgyz Republic should introduce immediate measures to improve the organization of the work of judges and better to monitor the way they do this. At the present time, unfortunately, the judiciary in Kyrgyzstan does not ensure impartial, open and fair trials. It is not in accordance with international standards when it comes to both material and procedural law. In Kyrgyzstan, judicial proceedings are organized on the basis, in fact, of a dual standard. Cases concerning acts of torture are extended ad infinitum, sometimes for many years. Very often, judges send off cases to protect themselves for additional consideration, for additional investigation, and there are many cases that continue for many years. There is an organization that has identified 40 cases that have continued, that have been on the books since 2011. Now, when it comes to the issue of human rights versus the counteracting of terrorism, here we have a few recommendations. Kyrgyzstan should adhere to international obligations on human rights protection, including requirements of international refugee rights. There should be amendments to the current legislation counteracting terrorism in accordance with general laws, general norms of international rights. We need to have an appropriate analysis and expertise of draft laws, and it is very important, of course, that training be given to members of the special forces when it comes to taking human rights into consideration when they engage in anti-terrorism activity. Unfortunately, our laws are not perfect. They do provide for the possibility of special forces to violate even the right to life. You can detain individuals just on the basis of suspicion. No information is provided about where they're detained, and so their fundamental guarantees are violated. Their family members are not even informed. Thank you.
Thank you very much. Our next speaker on my list is Golos Svobody, Public Foundation, followed by the Holy See. Golos Svobody, you have the floor.
Спасибо. В течение нескольких лет Общественный фонд «Голос свободы» проводит работу по...
In recent years, we have been trying to improve legislation against activities by the authorities and law enforcement staff that are in violation of human rights. Our legal experts have determined that of 180 patients who were interviewed, 111 of them were subject to degrading, inhuman treatment or torture. 75% of these said that they were arrested because they had narcotics planted on their bodies. They have not had access to their lawyers, neither when they were arrested nor during the investigation. This is a very serious problem, and one of the reasons that allows for the use of torture during investigations. Now, when we consider the so-called interviews that law enforcement authorities carry out with those who have been detained, we note that the detainee's rights begin to be recognized only once that person has confessed to a crime. So I would like to make a recommendation of the OSCE to implement its own document on ensuring that detainees are not subject to torture, and we advocate that there be procedural guarantees enshrined in national legislation, as well as codes on conscientious behavior on the part of lawyers, and the provision of a qualitative legal support provided to detainees. We would also like to call on governments to decrease pretrial detention terms. Thank you.
Thank you. The next speaker on my list is the Holy See, followed by the OSCE Action Against Terrorism Unit. Holy See, you have the floor.
Mr. Moderator, the Holy See's position on the death penalty has developed and has been clearly elaborated in recent decades. Pope Francis recently expressed to the President of the Commission against the death penalty that today capital punishment is unacceptable, however serious the condemned person's crime may have been. It is an offense to the inviolability of life and to the dignity of the human person, which contradicts God's plan for man and for society and his merciful justice, and it fails to conform to any just purpose of punishment. In his yesterday's statement at the joint session of the United States Congress, the Pope also emphasized that the global abolition of the death penalty is the best way, since every life is sacred, every human person is endowed with an inalienable dignity, and society can only benefit from the rehabilitation of those convicted of crimes. It appears evident nowadays that means other than the death penalty are sufficient to defend human lives against an aggressor and to protect public order and the safety of persons. For that reason, public authority must limit itself to such means because they better correspond to the concrete conditions of the common good and are more in conformity to the dignity of the human person. Pope Francis has on several occasions called also for the improvement of the conditions of imprisonment in respect of human dignity, adding moreover that even life imprisonment as well as those sentences which due to their duration render it impossible for the condemned to plan a future in freedom may be considered hidden death sentences, and denouncing at the same time the so-called extrajudicial and summary executions. One should also keep in mind that states take life not only through the death penalty and through war, but also when, in order to justify their crimes, public officials take refuge in the shadow of state prerogatives. So-called extrajudicial or extra-legal executions are homicides deliberately committed by the certain states and by their agents, often passed off as clashes with criminals or presented as the unintended consequences of the reasonable, necessary, and proportionate use of force in applying the law. Political and legislative initiatives currently promoted in a growing number of countries to eliminate the death penalty, as well as continuing substantive progress made in conforming penal law both to the human dignity of prisoners and the effective maintenance of public order, are moving in the right direction. The position of the Holy See on this issue is based on respect for the dignity of every human person, justice, and the promotion of the common good, positive principles in which there is a growing convergence in international human rights law and jurisprudence. Thank you, Mr. Moderator.
Thank you very much. The next speaker is the OSCE Action Against Terrorism Unit, followed by the International Association of Independent Democrats Against Authoritarian Regimes. OSCE Action Against Terrorism Unit, you have the floor.
The Action Against Terrorism Unit is mandated to serve as a focal point for the coordination and facilitation of OSCE counterterrorism activities. Our job is to assist OSCE participating states in fulfilling their commitments and international obligations in the field of counterterrorism, commitments which are many and cut across the three dimensions of security. This is the essence of the OSCE's comparative advantage. As a matter of fact, the first ever joint meeting of the OSCE's three committees, which was held this year in June at the initiative of the OSCE Serbian chairmanship, a joint meeting of the Security Committee, the Economic and Environmental Committee, and the Human Dimension Committee focused on countering terrorism, particularly from a human rights aspect. In the same spirit, the OSCE Transnational Threats Department counterterrorism team in Vienna continues to work closely and to have an excellent cooperation with ODIHR and other OSCE institutions such as the Representative Freedom on the Media to ensure that all human rights implications in our programs and activities are identified, understood, and appropriately included. I'd like to highlight a couple of points since our last HDIM presentation. OSCE participating states and partners for cooperation have been facing an unprecedented threat from foreign terrorist fighters and the brutal rise of the Islamic State in Iraq and Levant. This phenomena presents us with challenges that are not necessarily new, but are more acute, and the need to be consistent in our policies and to uphold human rights in the rule of law in response to this. The OSCE Serbian chairmanship convened an OSCE-wide conference June 30th and 1 July based on last year's declaration on foreign terrorist fighters adopted in Basel. ODIHR and RFOM were closely involved, and the chairmanship issued a perception paper, which I invite all of you to read. The conference concluded by underscoring that every time participating states undermine human rights, they undermine their own counter-narrative to violent extremism, which brings me to my second point. The OSCE has been actively involved since the beginning of the year in the summit process on countering violent extremism, which was launched by the United States in February as a call for action to counter the drivers of terrorism, which will be finalize its outcomes next Tuesday in a Heads of State summit chaired by President Obama, where our Secretary General will participate. For instance, our department submitted last year a draft good practices document on the role of women in countering violent extremism as a non-binding guidance. I believe we should focus our efforts going forward on practical implementation. For this reason, the OSCE Secretary General and the Serbian chairmanship have launched an advocacy campaign, OSCE United in Countering Violent Extremism. Earlier this morning, I was out front. I invite all of you out this door to take photographs under Twitter, under Facebook, in support of this campaign, which unites the comparative advantage against all OSCE efforts in countering violent extremism. It's important we implement and not just have words, but action. I especially encourage you to join the Youth Political Participation meeting at 1300 in room 3, where we will continue the important involvement of youth in this effort and to continue to promote the campaign. Thank you very much. I'm happy to talk to anybody at the conclusion of the session.
Thank you very much. The next speaker is the International Association of Independent Democrats Against Authoritarian Regimes, followed by the National Forum Ossetia Accuses. International Association of Independent Democrats, you have the floor.
Distinguished moderator, distinguished participants, Azerbaijan, Belarus, Kyrgyzstan, Turkmenistan, Kazakhstan, and aggressive Russia, these are countries of dictatorship. Dictators violate human rights and consistently pressure their citizens. That is dictatorship. We have very clear violations in terms of the use of torture. We have been providing information about these cases since 2003. But what has changed? Nothing. The dictatorships are using torture as a policy. Now, systems have been worked out, and we can unfortunately compare the use of torture in these different countries. There are forms of torture that are used in Belarus, but they are applied to individuals rather than groups. It is considered a norm. In the Asian countries, in Russia and Azerbaijan, torture is a mass phenomenon. But Belarus is the only country in Europe that enforces capital punishment. Since 2004, we have been making recommendations to the OSCE, participating states, to counter and monitor these events. We repeat our recommendations, and we propose that a mechanism for monitoring be formulated, as we have previously suggested. We call for the abolition of capital punishment in Belarus. The practice of torture should disappear from the OSCE region. We call on the recognize the steps taken by the United States and by the International Committee of the Red Cross. And we recall our appeal made about Azerbaijan during the OSCE seminar. We also note the topic that was changed at the Swedish-sponsored event to the Holocaust. There has been much discussion about the Poles saving Jews during the Holocaust, but Poles also killed Jews. Jews should never be killed, but nor should Ukrainians, French, Danish citizens. No one should be killed. We would not like for there to be undermining of topics that would be discussed at OSCE meetings. Thank you.
Thank you. The next speaker is the National Forum Ossetia Accuses, followed by Ukraine. National Forum Ossetia Accuses, you have the floor.
Mr. Chairman, dear colleagues, we're very pleased to welcome you here to this event, which is, of course, extremely important for our people, since it really is the only forum at which we can discuss problematic issues connected with violations of human rights in our region. In the course of the armed aggression by the Republic of Georgia against the people of South Ossetia and in the post-war period, there have been cases of illegal detention and deprivation of liberty of citizens of Ossetian nationality. There is incontrovertible evidence of inhuman treatment and torture of the abducted persons, and these facts can easily be verified by taking advantage of the internet, including YouTube. We have raised this issue on a number of occasions in previous years, in previous conferences, and we will continue to do so until this is resolved. There are individuals who have disappeared with no information about them. They have been illegally detained. A minor, Alan Khachirov, Alan Hugayev, Zoltan Pliev, who was abducted on 13 October 2008, Radik Ikayev, taken to prison on 8 August 2008. They're all citizens of Ossetian nationality, and these facts have been confirmed by the Council of Europe Human Rights Commissioner, Mr. Hammerberg. Expert analysis has verified that Khachirov, Hugayev, and Pliev were detained by the forces of law and order of Georgia on 13 October 2008, and it is worth stressing that one of them was a minor at the time. At the last meeting of the chairpersons of the Geneva International Discussions, which took place in the Republic of South Ossetia, the OSCE representative Angelo Gnedinger reported that work on this issue will continue, and a new independent expert has already been appointed. Dear colleagues, dear friends, in light of the above, we think that it would be appropriate to adopt the following recommendations to prevent violations of human rights. Developing mechanisms that would force Georgia to fulfill its international commitments under conventions of which it is a state party, and giving access to South Ossetia representatives to discussions in the humanitarian and political discussions of the OSCE, because we don't have that access at the present time. Thank you for your attention.
Pakistan, Ukraine, you have the floor.
The delegation of Ukraine joins with the statement of the European Union. We'd like to speak in a national title. Now, there are a number of factors that increase the vulnerability of our country to the terrorist threat in the area where the anti-terrorist operation is being carried out. There's a permanent increase in the border regions of a Russian military contingent. And beginning in 2014, we have seen a constant increase in the Russian armed forces in border areas of Belgorod, Voronezh, Bryansk, and Kursk, and in the territory of temporarily occupied Crimea. We have also identified cases in which there are Ukrainian citizens who are subject to psychological and physical pressure in order to cooperate with the occupying authorities against their will. There are Russian special services that are spreading among the local population without the knowledge of that population. In the southeastern areas and in border areas. There is an increase of the presence of international terrorist organizations, including representatives of ISIL, in the occupied territories of Ukraine. We have noted that there are close contacts that have been instituted between the Russian secret services and representatives of ISIL in order to recruit fighters. The members of terrorist organizations are trying to create a so-called transshipment point in the occupied parts of Ukraine in order to then send fighters to other countries. And the Ukrainian authorities have identified a number of agents in the Russian special services who were engaged in these activities. Now, we have also stemmed and countered possible terrorist acts. We must ensure a greater security in these regions. We were able to prevent in Kharkiv, Kiev, and other areas these potential terrorist activities. And we have identified more than 60 groups in the areas of Kharkiv and Kherson. A number of representatives, as I said, of ISIL have been identified, and we have been able to stem their activities. Thank you.
Thank you very much. The next speaker is Tajikistan, followed by the International Group on Crimes Against the Person. Tajikistan, you have the floor.
Thank you, Mr. Moderator. The combating of torture, preventing torture, is a very high priority for our action. In 2012, the president of the country, in a meeting with leaders of the forces of law and order, severely criticized torture and pointed out that it is unacceptable to torture or otherwise cruelly to treat individuals who have been charged with crimes. Now, the adoption in the country of appropriate legislation, including a criminal procedure code and a criminal code. There is a new article in the criminal code on torture that has been approved by the Supreme Soviet, and there are also appropriate instructions that have been given to the forces of law and order about treatment of detained persons. After the introduction of this article into the criminal code, a number of cases have been brought in connection with that, with a view to intensifying the fight against torture. Additional measures are being adopted. At the present time, we're working on amendments to the law governing the way people are detained and how they are treated in detention. And this provides for definition of the rights of detainees, the right to access to a lawyer, medical care that is obligatory for all detainees, and the setting up of video filming in places where these individuals are questioned. And the Council on Human Rights has set up a working group which includes members of various governmental entities, but also civil society, with a view to better monitoring and making sure that the optional protocol OPCAT is fully implemented. Various information campaigns are being held with the forces of law in order to prevent torture, and appropriate measures are being introduced to implement the Istanbul Protocol and to ensure that independent medical examinations are provided. A colleague from Tajikistan mentioned torture practiced against members of the armed forces, and I'd like to note that these cases are not covered by the article on torture. because one of the main definitional criteria is the objective of the torture, and in the case when members of the armed forces are subject to such treatment, this comes under a different definition.
Followed by France. International Group on Crimes Against the Person, you have the floor.
Добрый день. Максим Вилков.
I'm Maxim Velkov from the International Group on Crimes Against the Person. Now, since the situation developed in Ukraine, we have received a number of reports of the use of torture. We have eyewitness accounts, and they will soon be published. We have gathered information which allows us to talk about the creation by Ukrainian security forces of an illegal system of detention which is only ruled by arbitrariness. Now, this situation has been noted in the airports of Mariupol and Kramatorsk. We are certain that this illegal detention and the use of torture, as well as these illegal locations of detention, involve the armed services of Ukraine and the special services, as well as the National Guard. The illegal Ukrainian system has affected thousands of people who have been subjected to torture, and many have been killed. We call on the OSCE and international human rights defending organizations to appeal to the Ukrainian authorities to stop these crimes against humanity. Thank you.
Thank you. The next speaker is France, followed by the Council of Europe. France, you have the floor.
Merci, monsieur.
Thank you, Mr. Moderator. This morning we have heard a number of speakers talk about cases of torture, forced disappearance, inhuman treatment. This is still occurring in the region of the OSCE. The OSCE cannot remain deaf nor blind in the face of these crimes. As a participating state, we have a common responsibility to make progress on this issue. First of all, on capital punishment. The OSCE cannot be behind the wheel when it comes to combating capital punishment. We have all become convinced that this is contrary to justice, and a majority of countries in the world agree with that. Over the last decade, capital punishment has retreated. Two-thirds of the planet's states, and just 16 since 1997 have abolished capital punishment or introduced a moratorium. That is unfortunately not the case everywhere, but the OSCE can and must remain a model area by promoting abolition in all participating states. We call for bringing the commitments that we adopted more than 20 years ago up to date. Coming now to prevention of torture, we must urgently mobilize our efforts against forced disappearances. We cannot agree to impunity, as in the case of torture, and if we don't do that, we will be condemning future generations to continue to be victimized by this crime. The International Convention on the Protection of All Individuals Against Forced Disappearances, which came into force in 2010, fills in a legal vacuum. It covers individual cases, but also cases of systematic forced disappearances, which is a crime against humanity. And the Convention prohibits secret places of detention, provides certain guarantees for detainees, makes it possible for family members to know about the fate of their family member, and finally pays particular attention to the cases of children who are forcibly disappeared. France appeals to all participating states of the OSCE that have not yet done so to ratify this convention. And we believe that there is an imperious necessity to combat this phenomenon of forced disappearance within the framework of commitments taken on board by our organization to prevent torture. Thank you very much, Chairman, for giving me the floor.
Thank you very much. The next speaker is the Council of Europe, followed by the Historical Memory Foundation. Council of Europe, you have the floor.
Thank you, Mr. Moderator. Europe has been a de facto death penalty-free zone since 1997. Death penalty is now regarded as an unacceptable form of punishment, incompatible with the fundamental rights, the right to life, and the right not to be subjected to cruel, inhuman, or degrading treatment. De jure abolition of the death penalty in all Council of Europe member states and in all circumstances remains a central political objective of the organization. In its case law concerning states which had not yet ratified Protocol number 6, the European Court of Human Rights considered that it would be contrary to the Convention to implement a death sentence following an unfair trial. The Court also found that the evolution towards the complete abolition of the death penalty in law and in practice within all 47 Council of Europe member states had demonstrated that Article 2 of the European Convention of Human Rights had been amended so as to prohibit the death penalty in all circumstances. In the light of this finding, the Court held that the death penalty as such involves the deliberate and premeditated destruction of a human being by state authorities, causing physical pain and intense psychological suffering as a result of the foreknowledge of death. It could therefore be considered also to be contrary to the prohibition of torture and inhuman and degrading treatment and punishment under Article 3 of the European Convention on Human Rights. The Parliamentary Assembly of the Council of Europe has been a driving force in the movement to abolish the death penalty. It was at the origin of Protocol number 6 and has since adopted successive texts to outlaw the death penalty. The Parliamentary Assembly constantly exerts pressure in order to encourage abolition and insists on moratoria in individual countries, both in the context of examining candidatures for membership and in its procedure for monitoring the compliance of existing member states' commitments. Governments of member states have also strongly committed themselves to abolition. Every 6 months, the Committee of Ministers debates the situation of the death penalty on the European continent. The subject will continue to be considered regularly until Europe has become a de jure death penalty-free zone. The last exchange of views took place in April this year, and the next one is scheduled for the beginning of October. The Council of Europe has turned its attention also to non-European states, more particularly those with observer status with the organizations, since then are deemed to share the common fundamental values and principles. The Parliamentary Assembly has adopted a number of texts in which it requested the observer states who haven't yet abolished the capital punishment to make more efforts to take the necessary steps to institute a moratorium on executions with a view to abolishing the death penalty. The Committee of Ministers has also issued general declarations on the death penalty, condemning executions in the Council of Europe observer states. In their decisions taken on the occasion of its last biennial exchange of views on the abolition of death penalty, it called on the authorities of those observer states to promote a public debate towards the abolition of the death penalty, in the meantime ensuring that minimum international standards are met with respect to executions. The organization has also intervened through the Committee of Ministers or the Secretary General in a number of individual death penalty cases with a view to drawing attention of national authorities to the need to respect international human rights standards. Thank you for your attention.
Thank you very much. The next speaker is the Historical Memory Foundation, followed by Newsmaker MD. Historical Memory Foundation, you have the floor.
Distinguished colleagues, I'd like to draw your attention to the events taking place which currently create an unsafe situation and foster and will continue to foster in future human rights violations. A few days ago, the leader of the Ukrainian right-wing organization Right Sector, Dmitry Yarosh, told the media about the planned integration of some armed formations of this right-wing radical organization in the Ukrainian security services and intelligence services. Now, These groups within the Ukrainian security services are of great concern. The reason is that a number of international organizations, including Amnesty International, have recorded the participation of right sector groups in kidnapping, killing, and the creation of illegal detention centers. The integration of right sector formations into the Ukrainian special services will certainly provide conditions for continued violations of human rights and the use of torture as well as kidnapping. We'd like to call international human rights organizations and the OSCE to place pressure on the government of Ukraine and to avoid such a possibility. The integration of neo-Nazi groups into Ukrainian government services such as the Azov battalion has already demonstrated violations of human rights in Ukraine, and we would never want to see a situation in which the current conditions were to worsen. Thank you.
Thank you. The next speaker is Newsmaker MD, followed by the Association for the Prevention of Torture. Newsmaker MD, you have the floor.
Thank you. Dear audience, my name is Marina Shupak and I'm a human rights journalist from Moldovan online media newsmaker.md. And my statement refers to human rights protection and fighting terrorism. Taking in consideration the fact that lots of countries from OSCE region are the ones of transitional justice period and face fights with corruption and politically motivated persecutions, we would like to call upon OSCE member states and responsible units, as well as presented in here international civil society organizations and NGOs, to pay closely attention to the court cases involving groups or individuals proclaimed by persecutors as extremists or terrorists. I would like to illustrate my call on a concrete case from Moldova, which is under close monitoring of the editorial team I present at HDIM. It is a case of two oppositional activists, Pavel Grigorchuk and Mikhail Amerberg, members of organization Antifa Resists. Grigorchuk and Amerberg have been arrested 3 days prior to parliamentary elections in November 2014. Police and prosecutors told that they have prevented forced change of the government in Moldova by this arrest. Pro-governmental media avoided all the principles of presumption of innocence and called the activists arrested as extremists and followers of bloody Maidan. Official accusations of prosecutors have been changed several times since November. Grigorchuk and Amerberg have been accused initially in preparation of mass disorders, then in organization of criminal organization, afterwards in organization of mass disorders. Initially, prosecutors called Antifa Resist as a criminal organization. Afterwards, this syntagma disappeared from the documentation. 15th of April 2015 is the day Grigorchuk and Amerberg have been transferred from arrest in the jail to the home arrest. Today, another court hearing of the case is planned in Chisinau. At last but not least, I have to mention that Grigorchuk and Amerberg risk to get from 8 to 15 years of custody, and they risk to get another 8 years of imprisonment because of the protest they have organized at 6th of September in front of General Prosecutor's Office. I told about this case at the session on 23rd of September when right to peaceful assembly was discussed. I call upon all presented to closely monitor this case. Justice sector reform in Moldova are stopped, and Moldova is described as a captured state not only by internal actors, but also by Council of Europe Secretary General Mr. Jagland. Thus, international community attention over such cases matters a lot. Thank you.
Thank you very much. The next speaker is the Association for the Prevention of Torture, followed by the Interregional Social Movement for Democracy and Human Rights. Association for the Prevention of Torture, you have the floor.
Thank you, Mr. Moderator. The Association for the Prevention of Torture would like to take the opportunity of this session on the prevention of torture to welcome the enhanced focus of the OSCE on the topic and the creation of a dedicated position within ODIHR. We would like to recall that a set of preventive measures can indeed be taken to effectively reduce risks of torture and ill treatment by building effective legal frameworks, ensuring effective procedures and practices, and enabling effective and independent oversight. The OSCE has the capacity to strengthen all these elements of prevention and contribute to ensuring their effectiveness. We call on the OSCE to make full use of its resources and develop its expertise to advance the combat against torture and the protection of all those who are deprived of their liberty in its participating states. Among other important elements, the APT would like to specifically emphasize the instrumental role that the OSCE could play in ensuring effective oversight of places of deprivation of liberty throughout its region. Unfortunately, national preventive mechanisms sometimes lack the independence, adequate human and financial resources, or the unimpeded access to all places of detention, persons, and information required to effectively implement their preventive mandate. We encourage the OSCE to further develop its role in this regard and to support NPM and strengthen their capacities and effectiveness in its participating states. It is well known that the risk of torture and ill treatment is higher in the first few hours of police custody, and we would also like to remind that the OSCE's contribution to reducing them through cross-cutting work on its first and third dimensions of security could be instrumental. The APT calls on the OSCE to increase its torture prevention work with the police and other law enforcement officials and contribute to reducing the risks of torture in police custody throughout the OSCE region. The APT would also like to invite the OSCE to expand its well-known expertise on combating discrimination so as to address this issue in situations of deprivation of liberty. The APT believes that the OSCE could greatly contribute to advancing the protection of individuals and groups in specific situations of vulnerability in detention, among others by raising awareness on their situations and needs and enabling the setup of effective risk mitigation measures. Finally, the APT would like to emphasize that the primary responsibility of preventing torture and protecting the rights and dignity of all those who are deprived of their liberty lies on states. All 57 OSCE participating states are parties to the UN Convention Against Torture. The OSCE region also bears the highest number of OPCAT ratifications worldwide, with 41 participating states being parties to this treaty, and hence having committed to opening up their places of detention to external and independent oversight. Yet we know that torture and ill treatment remain prevalent in the OSCE region. The APT calls on all OSCE participating states to follow up on their commitments to combat and prevent torture and ill treatment, and to ensure that all persons deprived of their liberty are effectively protected from any abuse. Thank you very much.
Thank you very much. Before we continue, I remind to representatives of delegations that should any delegation would want to exercise the right of reply, they should indicate that to my colleagues here. Now, our next speaker is the Interregional Social Movement for Democracy and Human Rights, followed by Armenia, Interregional Social Movement for Democracy and Human Rights. You have the floor.
Good day. Much has been said today about torture and cases of torture on the territory of Ukraine in the context of the conflict, the civil conflict. But I would just like to mention that there are some very propitious circumstances created by the Ukrainian government for the exercise of torture, because I'd like to mention something that has not yet been mentioned today, namely the laws adopted by the Rada, the Ukrainian parliament, in May of this year, which provide for the overturning of certain points or certain provisions in international pacts and covenants that concern human rights. On 21st May, the Parliament voted in favor of an adoption of the law. Then on the 25th it was signed, and according to this law, 3 international pacts are no longer applied, or at least some provisions of them. The first one is the Convention on Human Rights and Fundamental Freedoms. I think we all know that document. The Ukrainian government does not guarantee 5, 6, 8, and 13 in the zone of conflict. The second one is the International Covenant on Civil and Political Rights adopted by the UN, It's 2, 9, 19, 14, and 17. Those points are not applied, and they provide for the integrity of the person, for equality before the courts, and for the presumption of innocence. And the third one is the European Social Charter, so they're not applicable in the zones of conflict. Now, this new Ukrainian law is a follow-up to a series of laws that were adopted, amendments as well, that were adopted last year in Ukraine. There's official information about this, which you can read on the official site of the Ukrainian Rada, or the parliament. And I'm drawing your attention to this because I think that this is very important. And I would like to just add a short comment concerning the statements made by my colleagues representing the civil society of Ukraine, talking about a war that is allegedly being waged by Russia against Ukraine. But despite the catastrophic situation in relations between our two countries, and yet there still is trade, there still are business contacts, there still are exchanges, and a very large number of Ukrainian businessmen have interest on the territory of Russia, vice versa. Pyotr Poroshenko, the president of Ukraine, himself has business interests on the territory of Russia. Thank you.
Is Armenia, followed by the Foundation for the Study of Democracy. Armenia, you have the floor.
Thank you, Mr. Moderator. Yeah, it works. Yeah, thank you. The right to be free from torture and other ill treatment is a basic human right, full implementation of which requires goodwill, systematic work, and international cooperation. Armenia acceded to the OPCAT and closely cooperates with the subcommittee on the prevention of torture. Yet breaches of the OPCAT obligations unfortunately still persist in the OSCE area. We are deeply concerned by continued cases of torture and extrajudicial killing of the citizens of Armenia by Azerbaijani armed forces and law enforcement agencies on the borderline territory. Amid many cases, the torture and killing of Mr. Karen Petrosyan, Armenian civilian from borderline settlement Chinari, is the most shocking one. In August 2014, Mr. Karen Petrosyan was subjected to humiliation, degrading treatment and torture in front of cameras, and in some hours he was assassinated. Post-mortem examination reaffirmed that Mr. Petrosyan was brutally tortured and killed. In recent times, two other Armenian civilians from borderline settlements, Mamvel Saribekyan and Mamikon Khojoyan, were also publicly humiliated, tortured in Azerbaijani custody, which resulted in their deaths. As far as degrading treatment of Armenian prisoners of war are concerned, the torture and degraded treatment of Armenian POW Hakop Injigulian are well documented by Azerbaijanis themselves, and the coverage of this interrogation was found during the arrest of the group consisting of Mr. Hassan Hassanov, Shahbaz Guliyev, Wilhelm Askerov, who perpetrated and committed crimes against inhabitants of Nagorno-Karabakh, on which my delegation has already referred on a number of occasions. The continued attempts of Azerbaijani armed forces to terrorize borderline population of Armenia are a threat to regional security. Just yesterday, 3 Armenian civilians, all of them women, Sona Revazyan, 41 years old, Paytsar Agajanian, 70 years old, and Shushan Asatyan, 91 years old, from 2 borderline settlements, Pertavan and Paravakar, were killed by Azerbaijani armed forces, which shells borderline villages from mortar launchers. We strongly condemn these inhuman actions. We would like to remind to the Azerbaijani side that systematic application of torture in conflict environment may amount to crimes against humanity in accordance with international law. My delegation has already expressed its readiness to engage in dialogue with Azerbaijani delegation. The dialogue presupposes at least basic level of good faith and integrity. Unfortunately, Azerbaijani delegation brings initially, and I would say intentionally, false information on which it is not possible to engage in dialogue. For example, just at this meeting, Azerbaijani delegate claims that there are 4,000 Azerbaijani prisoners of war in Armenia as a result of Nagorno-Karabakh war of early 90s. According to ICRC, there are approximately 3,600 missing persons from Azerbaijan, 400 missing persons from Nagorno-Karabakh, and 400 from Armenia. We don't think that Azerbaijani delegation does not understand the difference between missing person and prisoner of war. And thus, we would like to call upon Azerbaijani delegation to raise this issue in good faith. In the constructive manner, we would like to inform to Azerbaijani delegation that currently there are no any prisoner of war in Armenia. Thank you.
Thank you very much. The next speaker is the Foundation for the Study of Democracy, followed by the Civil Activity Fund. Foundation for the Study of Democracy, you have the floor.
Distinguished Chairman, distinguished participants, 3 months ago, the main military prosecutor of Ukraine brought charges against Ukrainian on charges of torture of civilians and minors in Donbass. This is official Ukrainian information. The systemic use of torture is characteristic of Ukraine today. Here you see Vitaly Korobkov of the Ukrainian self-defense authorities. He was apprehended by the right sector. There are definite signs of torture here, and they were even published on Facebook. The deputy of the Ukrainian parliament openly shows the methods used, and they're shown on Ukrainian television, of the questioning of detainees. We have noted more than 200 victims of torture during the so-called anti-terrorist operations in the east of Ukraine. We have a video and written documents demonstrating the participation of Ukrainian special forces and National Guard in treating prisoners with inhuman and degrading treatment, as well as the use of torture, leaving detainees without a medical assistance, and also the systemic use of rape against female prisoners. We have heard about the events at the airport of Mariupol, where there is an illegal detention center where torture is taking place. Now, after the United States training of Ukrainian forces, the latter have begun to use American torture practices, and these are documented in the book that I have here with me. A number of international organizations, Human Rights Watch, Amnesty International, have reported on this, and they have provided detailed examples, as I have. Unfortunately, a number of specialized organizations continue to be silent about these violence, and Senator McCain of the United States is pictured here with members of the Dnieper Battalion. The Dnieper Battalion has also applied torture. It is referred to in our report. There's official Ukrainian information about those arrested for separatism. And Russian journalists have reported on this. I would ask the OSCE to do everything possible to ensure that the Ukrainian practice of torture is curtailed. Thank you.
Is the Civil Activity Fund, followed by Belarus. Civil Activity Fund, you have the floor.
Good day, ladies and gentlemen. The Fund for the Study of Democracy, Civil Activity Fund, my name is Akbarbayev. In 2015, in April, we will have the 4th anniversary of the Zhenevitsky events. This is the most unfortunate and dramatic event in the modern history of Kazakhstan. It started in 2011 when 5,000 members in the gas and workers in the gas and oil industry struck. On 16 December of 2011, the security forces shot at peacefully demonstrating citizens in the center of the town concerned. As a result of those events, on that day, 14 persons died. The total number, according to official data, who lost their lives was 18. But there's also evidence about secret detentions. Previously, there were 100 persons secretly detained, but apart from that, about 1,000 persons were detained by police officers and secret service officers who were kept in cells in a temperature of -40, and they were subject to massive cases of torture. I mean, this is the most widespread case of torture being exercised by the forces of law and order of Kazakhstan against peaceful citizens. But unfortunately, the OSCE and the international community have reacted very weakly to these events. The only group that expressed a strong position was the European Parliament. Thank you very much to the Parliament for that. It adopted two resolutions calling for an international investigation into these events. My comrade Kozlov is now in prison. He is subject to torture. He's not allowed to leave. He's not be visited. He's one of the first to be judged on this. Now, all of the others found guilty of these events are, including police officers, are completely free and undetained. And I would call on the delegation of the United States, which for some unknown reason remained silent about these events, to put pressure on the Kazakh authorities to open an investigation and to call on Kazakhstan to release Mr. Kozlov, who is not guilty of anything, who was determined guilty as a scapegoat. For 7 months, the authorities paid no attention to the strikers, and then they shot them and tortured them. Thank you for your attention.
Thank you very much. The next speaker is Belarus, and we will then move on to those delegations that have expressed their interest in exercising the right of reply. Belarus, you have the floor.
Thank you, Mr. Moderator. According to the Constitution of the Republic of Belarus, death penalty is applied until its abolition, I emphasize, until its abolition, as an extraordinary form of punishment for especially grave crimes. Belarus follows the global trend and takes necessary steps towards gradual abolition of the death penalty. My country has been systematically working on the humanization of its criminal code and law enforcement practices. The category of persons to whom the death sentence cannot be applied was expanded and now includes children under 18, all women and men over 65. In all cases, the court has the right to choose between death penalty and alternative punishment. The legislative process continues to limit the scope for death penalty application. In January this year, the amendments to the criminal code made possible to apply an alternative punishment in case of the pretrial agreement. The Belarusian government and the parliament paid due attention to this issue. The working group in the parliament continues its activities. In 2014-2015, the members of the group took part in the range of the events dedicated to the death penalty. Belarus stands ready for further open dialogue and cooperation with partners on the issue of the death penalty. Thank you.
Thank you very much. Before we move on to the right to reply part of our discussion, we have some time to give the floor to Mr. Modvik for some comments and remarks he has at this point.
Thank you, Mr. Moderator. In 2003, I had the pleasure of being one of the panelists in a supplementary human dimension meeting in Hofburg, Vienna on the prevention of torture. Last year, in 2014, under the Swiss chairmanship, there was another supplementary human dimension meeting on the prevention of torture. At that meeting, the Secretary General of the Association for the Prevention of Torture, Mr. Mark Thompson, unfortunately had to conclude that the challenges that appeared in 2003 still remained in 2014. Last year, 2014, was also the 30-year anniversary of the United Nations Convention Against Torture. And while there was a celebration of this anniversary, there was in fact not so much to celebrate because the problem of torture prevails and has not yet been eradicated. I think the interventions today have confirmed very much that there's a need for us to join forces, and it's time now to do a better job in the prevention of torture than have been done hitherto. There are new initiatives. I have mentioned the Convention Against Torture initiative. I have mentioned the United Nations treaty body strengthening process. But I think there's a huge potential in joining forces between the Committee Against Torture and the OSCE, and several of the participating states' interventions have actually confirmed that a stronger mobilization of OSCE is a part of the right response to this problem. So I would like to reiterate my belief that a stronger collaboration between the field missions of the OSCE and the framework provided by the Committee Against Torture in the concluding observations could very well be the making of a real difference in this important issue of eradicating torture in the OSCE region. Thank you very much.
Thank you very much, Mr. Modvig, for your remarks that somehow bring to a conclusion the discussion, the rich discussion we had so far. We now have indeed time for right to reply, and the first speaker on my list is Luxembourg on behalf of the European Union, which will be followed by Georgia. And for the right of reply, we will allocate 2 minutes for each statement. Thank you. And Luxembourg, you have the floor.
Thank you, Mr. Moderator. I want to take this opportunity to respond to a number of the comments that were made in the statement by the Russian Federation. Firstly, I want to reiterate that the EU condemns all forms of torture and ill treatment under any circumstances, including in counterterrorism, and is working towards their prevention and eradication within the EU and worldwide, and as a priority of its human rights policy. Cases of concern are regularly raised by the EU in the context of our bilateral human rights dialogues and other dialogues with countries. Secondly, regarding the comments on enforced disappearances, we raise the issue of enforced disappearances as it is one of several areas of grave concern. Rather than being an abstract concept, as was suggested by our Russian colleagues, I would like to remind them that enforced disappearances is the focus of an international convention, as well as a declaration adopted by the UN's General Assembly. And having listened to the statements and testimonies that have been made in this hall and in side events outside it, I think it is clear that the issues that we are facing in this area are far from abstract. I would note in this context that the concerns that the Russian delegation seeks to bring into our discussions on torture prevention in Vienna are issues that they identify that there isn't at the moment an international framework or resolutions to act as a basis for our work. Nevertheless, we stand ready to engage constructively with Russia and others on issues of concern and working towards the adoption of a robust OSCE decision on torture prevention. Finally, in relation to the comments on the issues of refugees, IDPs, and the wider migration crisis, we will address these in full in our statement at the working sessions on Monday. Thank you very much.
Thank you very much. The next speaker on my list is Georgia, followed by Uzbekistan. Georgia, you have the floor.
Thank you, Mr. Moderator. I would like to use the right of reply and respond to the allegations presented by the representatives from the NGOs Sandizan and Ossetia accuses. Due to time constraint, I will focus on main details. In October 2008, Russian authorities informed the law enforcement agencies of Georgia about the disappearance of 3 persons, Mr. Pliev, Mr. Khachirov, and Mr. Khugayev, from the territories controlled by Russian forces on the ground. Based on obtained information, a criminal case was opened in Georgia. From the very beginning, the occupation regime, in the first line, the Russian forces, did not cooperate and hindered the investigation by withholding important information relevant to the investigation. Requests of the Georgian law enforcement agencies to share the detailed records of missing persons, location data, which must have been registered by the Russian mobile services operating on the occupied territories, was always turned down by the Russian authorities. In October 2012, the case was reopened and the investigation is still running. However, the occupation authorities continue to withhold important information and ignore requests of the Georgian law enforcement agencies, which could help advance the ongoing investigation. On my side, I would like to remind the case of missing Grigol Nalbandov. Mr. Nalbandov disappeared in 2008, and since then any trace of his is lost. Despite several requests of the law enforcement agencies of Georgia, no investigation was steered and no one was questioned by the occupation authorities over the case. I would like to use this opportunity and call on the occupation authorities to contribute to the investigation into the missing persons mentioned above and stop withholding relevant information on them. And finally, we find it cynical that participant from Tskhinvali region accuses Georgian authorities of illegal detentions, since Russian border guards, along with Ossetian militia stationed along the occupation line with the Tskhinvali region, continue to illegally detain the local population for crossing the so-called border on a daily basis. Just to illustrate, since the beginning of 2015, 108 local residents have been detained. Thank you, Mr. Moderator.
Thank you very much. The next speaker is Uzbekistan, followed by the Russian Federation. Uzbekistan, you have the floor.
Thank you, Mr. Chairman. I'd like to use my right of reply and to inform listeners that the United States representatives and Amnesty International representative statements regarding torture in Uzbekistan are based on unreliable sources and are a prejudiced approach to information on human rights protection in Uzbekistan. There is a reference made to the activities of the law enforcement authorities, and I'd like to note that when there are appeals made against treatment by the former, they are investigated within 3 days' time. And there is an working group on an intergovernmental working group that is headed by the Ministry of Justice on treatment of detainees. I'd also like to note that in keeping with the 2010 decree, the Ombudsman and the National Center on Human Rights of Uzbekistan, representatives of these organizations are able to carry out independent investigations of any claims of violations of human rights. Illegal practices are investigated by inspectors who are equally independent, and they are not criminal investigators. I would also like to note that the prosecutor every 10 days monitors the conditions of temporary detention. What's more, the prosecutor's office also applies this practice to those who are detained in isolation. I would also like to note that corresponding measures are taken when necessary. Thank you.
Thank you very much. The next speaker is the Russian Federation, followed by Ukraine. Russian Federation, you have the floor.
In answer to the statement made by the United States, I would like to remind everyone that it is the United States that is responsible for what is happening today in Ukraine. Their direct interference in the internal affairs of another state, something that the United States has been done for a long time, resulted in an overturn of the legitimate regime as a result of a civilian movement. Now, to blame Russia for the armed conflict in Donbass is unfounded. The International Committee of the Red Cross has also refused to identify this as an armed conflict of an international nature. Now, a state that is not respecting international standards. It is the policy of the United States that resulted in this terrible phenomenon, which is of a dangerous threat for all participating states of the OSCE. The United States is one of the few countries left to practice capital punishment and to do this in a particularly cruel manner that is reminiscent of the times of the Inquisition and the inhuman and cruel treatment of prisoners in Guantanamo. I mean, this is something for which no one has been held liable. Now, there has been some report on the success in the fight against terrorism, but this can all be done without resort to torture and treating individuals. What the Kiev authorities are doing on the basis of their ultra-nationalist policy is not acceptable. Now, insofar as Georgia is concerned, I'd like to remind you that Abkhazia and South Ossetia are independent states, and I think that what the Ukrainians are stating is something that could be, or the Georgians are stating something that can be resolved independently with the authorities of those states.
John, Ukraine, you have the floor.
Thank you for having given me the floor. Now, with respect to the statements made, I'd like to note that Ukraine, first of all, it's not civilians are trying to withstand a Russian military operation that has taken thousands of lives. With respect to the allegations about illegal detention centers, there are no such centers in Ukraine. This has been emphasized in September of 2014 by representatives of the Committee Against Torture and by representatives of the Council of Europe. It was clearly demonstrated that they did not find any illegal treatment of prisoners. I would like, on the contrary, to note the conditions under which Ukrainian prisoners are held by the so-called authorities of the DPR and LPR. And I refer to the cases of Yerofeev and Alexandrov. There have been many cases and proof of torture used by the pro-Russia militants. And there was one confession of one such person having shot personally 15 Ukrainian prisoners. With respect to this, I'd like to recall that on 25th May, it was clearly published. And with reference to Article 115 of the European Convention on Human Rights, I'd like to state that under this article, governments are unable to exempt themselves from the provisions of the convention. Now, the situation is extremely worrying. We have officially recognized the threat to the territorial integrity and sovereignty of the country. In such a situation, the European Convention on Human Rights must be enforced. Ukraine has recognized the jurisdiction of the International Criminal Court to crimes taking place in Donbass. Thank you.
Thank you very much. The next speaker on my list is Azerbaijan. Azerbaijan, you have the floor.
I would like to exercise the right of reply regarding the statement made by respective representatives of of the United States of America and Armenia. Within the framework of legal reforms successfully carried out in Azerbaijan in recent years, consistent measures have been taken with the view of modernization of penitentiary system, improvement of infrastructure, humanization of legislation, protection of the rights and freedoms of arrested persons and convicted persons, their legitimate interests, adoption of their detention conditions in the line with the international standards. Azerbaijan has cooperation in the field of monitoring of penitentiary services, not only with national organizations, but also with international organizations such as Red Cross, CPT, with UN organizations. I don't want to enter in debate with distinguished Armenian delegate. I just want to remind him that it's Armenian civilians that run from Armenia ask for asylum in Azerbaijan. Besides, it's Azerbaijan who are most vulnerable people on the front of line. It is Azerbaijans who forced ethnic cleanings, what Armenian side is justified. Azerbaijan will continue to use any international platforms to raise the issue of Azerbaijani civilians hostage and call international organizations and states to assist us in immediate liberation Azerbaijan hostages due to concern of their physical destruction. Thank you for your attention.
Thank you very much. I see the Armenian delegate would like to exercise a right to reply, so please, you have the floor.
Thank you, Mr. Moderator. I would have a very brief right of reply with regard to the statement just made by our Azerbaijani colleague. As I understand, I brought certain cases, very concrete cases, and Azerbaijani delegate did not make any comment on the substantive, on the substantive part of my inquiry. And this gives me an assumption that he agrees with with my assessment. And since he did not challenge my assessment on number of cases where Armenian citizens were arrested, tortured, and killed by Azerbaijani armed forces and law enforcement agencies. And second, we should not try to justify torture and extrajudicial killings of civilians by the persistence of the conflict. If we go into that direction, this would be complete dehumanization of each other, and this would completely destroy the respect towards OSCE commitments. Therefore, I would like to use this opportunity to call Azerbaijani delegation to strictly adhere its international obligations with regard, including with regard to Armenia. As far as the two convicted persons are concerned, my delegation has already exhaustively gave information about those persons. Their trial was very transparent with participation of mass media, and their guilt is proved. And in sake of justice, they should serve that justice. Thank you.
Thank you very much. The United States of America have expressed intention to exercise their right of reply. So, United States, you have the floor.
Thank you, Mr. Moderator. We note the statements made by several participating states that mention the United States, some of which were constructive, and also a question regarding U.S. security assistance training. But in the interest of this very late hour, we're going to reserve the right to reply on those matters. However, the allegation that the U.S. is responsible for the situation in Ukraine is simply unfounded and ridiculous. Thank you.
Thank you very much. There are no further right of reply requests, so I would like to conclude this session. Before I thank everybody, I would like to make an announcement. ODIHR is offering a free tour of the Jewish Museum, Poland, on Sunday, the 27th of September at 2:30 p.m. Those of you who will be staying for the weekend are very welcome to sign up and participate. Having visited it myself, I can certainly say that this museum is very interesting and worth a visit. So please sign up if you're interested. Finally, I would like to thank first and foremost Mr. Modvig for his contributions, all of you for your statements and interventions. I would like to thank my audio colleagues for their support in moderating this session, and finally our interpreters for their work in facilitating communication during this working session. Thank you very much.